What four people? I'm sorry, I don't understand.
Well, that's what I'm trying to get to. You're aware that J.J. Vallow was allegedly murdered either in an apartment of Lori Vallow's or a close proximity to that. You agree with that, right?
I don't know that we know exactly where he was killed. No.
Okay. But you do know that J.J. Vallow was being watched by Alex Cox that day and that evening of the 22nd, correct?
Partially, yes.
Okay. And you know that Melanie Gibb was there on the evening of the 22nd at Lori Vallow's apartment, correct?
That is correct, yes.
And you know that David Warwick was there on the 22nd on the evening of the day or the day that J.J. Vallow was murdered, right?
Yes.
Okay. And so we have Lori Vallow, correct? On that day?
Yes.
Alex Cox on that day, correct?
Correct.
Melanie Gibb on that day, correct?
Correct.
David Warwick on that day, correct?
Correct.
So I'm having some difficulty with you bringing up these Google searches. And this is why I'm having some difficulty is you're talking today about searching these people's and talking about events, and we'll get to these events in a minute. I don't see any Google searches on Melanie Gibb or David Warwick. And why is that?
Your Honor, I'm going to object as argumentative.
Overruled.
Why don't I have any Google search information on Melanie Gibb or David Warwick?
I'm not aware if I don't know off the top of my head if any legal process was served on those individuals or not.
Well, and this is what I'm having some difficulty with. This is what I'm struggling with.
Your Honor, objection to the narrative. If he wants to ask a question.
I'll sustain that. Just
Okay.
questions, Mr. Pryor.
Okay. Well, if David Warwick and Melanie Gibb were present for the murder of J.J. Vallow, why aren't we looking into their Google searches?
I don't actually write the search warrant, sir, so
Okay.
I'm not sure if they were who would have done that.
Okay. But it's common knowledge that they were at least there, right?
For a partial time, yes.
Right. Okay.
Yes.
Okay. Now, you're also aware as part of your investigation that, and we can discuss when we think this took place, but Chad Daybell and Lori Vallow were having a relationship, correct?
Yes, sir.
And they were engaged in a romantic relationship.
Yes, sir.
And it may have been when Charles Vallow was alive. It may have been after that, but we do know that after Charles Vallow's death, Lori Vallow and Chad Daybell were in a relationship.
That's correct.
And Chad was still married to Tammy Daybell at that time, correct?
Yes, sir.
Okay. When someone's in a relationship and you're looking at Google searches, could some of these Google searches be explained that he's trying to hide his extramarital affair with Lori Vallow?
I'm sorry, I don't quite understand that.
Well, let me go over it this way. You saw on 3/6 of 2019, May 6th of 2019. Would you like me to put this up so we can look at this? Would that be easier for you?
Sure. Yeah.
Oh. You have to tell me how I operate this. That's going to be a problem.
Which exhibit is this?
Judge, I don't have the number on it. It was what Ms. Blake was just talking to as part of the attribution and the Googles.
That 184A?
I think so.
Okay, 184A, then I'll note, not the PowerPoint, but the printout copy can be displayed to the witness and published for cross-exam.
And please excuse me, at my age, technology is just getting hooked up to Bluetooth is a challenge for me. So we're looking at 3/6 of 2019, right?
Correct. Yes.
Okay. Now, before I start, one of the things I have some difficulty with is we don't know who did these Google searches, right?
Correct. I cannot say that I witnessed Chad Daybell type these into a search bar, but somebody with access to the Chad Daybell account
So if there was,
conducted searches, yes.
Judge, I'll pause. I'm sorry. The next question's already in my head and it's just getting it to spit out and I'll try to control myself a little bit. So you put this off of a computer at Chad Daybell's house, right?
I reviewed a search warrant return from Google is what I
Okay.
was looking at. So not the computer directly, no.
So other than the time when Tammy Daybell passed away, are you aware that there were 3 or 4 other people who were living in Chad Daybell's house at the time?
I don't know. I think at least one child, but there could have been more. It's possible,
Okay.
yes.
Okay. So we don't know who actually did these searches, right?
Or I don't know from what device these were searched. No. I mean, it could have been a phone. You could be logging into from different devices, correct?
Okay. So I want to start, and we'll deal with the Ned Schneider ones in a minute here. 3/6/2019. Tammy Daybell's still alive, right?
Yes.
Now, I'm looking at that, and on 3/6/2019, Chad Daybell was already in this relationship with Lori Vallow, right?
Correct.
So, and I don't want you don't have to say what you're thinking, but it looks like June 26th star sign are Cancer, Lead compatible, and Leo compatible. And also May 4 sign Taurus and Leo compatible. That's what that is, right?
Correct.
And what your testimony said is that it looks like someone's trying to see whether, if we assume that it's Lori Vallow and Chad Daybell in the Cancer and Leo, right? That's what you're sort of implying to this jury, isn't it?
Well, based on the birth dates, May
Right.
4th and June 26th, correct? Yes.
Okay. And based on the birth dates, May 4th of Taurus and Leo compatible as well, right? On March 6th.
Yes.
So if someone is trying to find out and is involved in an extramarital relationship, and you're Googling whether or not your current spouse or your new girlfriend are compatible, that would be a reasonable explanation, would it not?
Yes, sir.
Okay. And then we go back and look at the Malachite, eBay Malachite jewelry on May 5, right?
Correct.
Okay. And if you're talking to someone that you're having an extramarital affair, and they encourage you to say, oh, someday maybe we could be together. I love Malachite. And she starts dropping hints. That could be an explanation for that as well, right?
It could, but I believe that Chad's Malachite searches began before Lori's.
Oh, yeah, but I understand the searches.
Oh, I'm sorry. Okay.
I understand that. But why don't you show me the phone records where they talked about Malachite and that Lori Vallow and Chad Daybell discussed the issue of Malachite? Did you see any of those?
I can't remember if there are in any text messages or not, but ultimately they purchased wedding bands that were Malachite wedding bands. Yes.
Okay. Okay. And were you also aware that during this time, there was discussion with Alex Cox and Zuluma Pastenes about Malachite as well?
I don't remember off the top of my head. No, sir.
Okay. All right. So we don't know whether this search for Malachite was a discussion between a boyfriend and a girlfriend, or whether or not it was about Alex Cox and his future marriage to Zuluma Pastenes, right?
Objection, Your Honor. States facts not in evidence and argumentative.
Sustained.
Now, the Ned Schneider issue. Again, when was Charles Vallow murdered by Lori Vallow and Alex Cox?
July 11th, 2019.
Okay. So there was a discussion about this, And the first time you ever heard about Ned Schneider was when Charles Vallow brought it up in an audio recording about his wife at the time, correct?
I believe that's correct, somewhere in
And
early
the-
January.
And the date of that was when?
I don't have the exact date of the body cam recordings or the police reports, but it's I believe it's pretty close to this time frame.
Prior to that time frame, right?
Yeah, right in that general time frame.
Okay. So, and in that general time frame, there was a discussion of Ned Schneider, right?
Yes, sir.
And at that point, it's your position that Lori Vallow and Chad Daybell were involved in an extramarital affair at that point.
Yes, sir.
Okay. Did you happen to look into the fact that Charles Vallow and Lori Vallow called off their divorce and tried to reconcile their marriage in February of 2019?
I do. Yes, I do remember that. I don't remember the time frame, but that sounds probably pretty close. Yeah.
You don't remember exactly when in February, but they did attempt a reconciliation and basically tried to renew their relationship, right?
Yes, sir.
Okay. So the idea of Ned Schneider, you didn't see anything else in Chad Daybell prior to January 28th of 2019, did you?
Did I see anything
With Ned Schneider and Chad Daybell making any look into what Ned Schneider was all about, right? Prior to this?
prior to, no, this was, I believe was the first search, at least in this time frame,
Okay.
that Ned Schneider appeared in Chad's Google searches.
Okay. So at that point, we can't make any assumptions, obviously, right?
No.
Okay. But we do know that as far as you're concerned, on the 28th of January, 2019, somehow Chad Daybell learned about the topic of Ned Schneider and decided to do a Google search and see what that was all about, right?
Objection, Your Honor, misstates the testimony.
Overruled. You can answer.
I don't know if he learned of it or if he was doing searches. He did searches for various individuals pretty frequently.
Right.
This is the only one that we found that had connection to other pieces of evidence in the case.
And you just led into my next question, and thank you for doing that.
Yeah.
Because when I reviewed all of this evidence, I saw that it was not uncommon when a topic came up for someone who was using that computer to do a search on a number of different topics. That would be fair, wouldn't it?
Absolutely.
Okay. So if he were to learn about the name Ned Schneider, it would be consistent with his or whoever was using that computer to Google it and see what it was all about. Would that be fair?
Potentially, I can't speak of when he learned that name or if he was
Okay.
searching it like he was a lot of other names. I'm not sure the order of that, no.
But his history shows that there's a lot of inquiry into various names, various topics, and that was something that was going on that computer quite frequently. Hundreds of thousands of searches, right?
Certainly lots of searches, yes.
Right, right. And then we go down to Malachite, and we don't know where he got the name Malachite from, but then he started searching that as well, right?
Correct.
And then he got to Hiplos, and we don't know what the story is on Hiplos, but he typed in that name, so he must have got the name from somewhere and started as that, right?
Correct.
And then you get down to 7/19 of 2019. Now, when you say you surprised someone with accusations, we don't know who typed that in, right?
Again, somebody, I can't say specifically, but somebody with access to the chad.daybell@gmail.com account.
So it could be someone's trying to learn about how you react when a spouse finds out that you're cheating on her, right?
Yes, it could be.
Okay. And we don't know who did the south-southwest wind and what is the definition of that, right?
Again, all I can say is it was somebody with access to that account.
Right. And when you're talking about the day before the accusation is, or the prosecutors claiming that may have been the day that Kylie Ryan was put in the ground on 9/9, but you're also aware that on 9/9, Chad Daybell sent an email to his wife at the time, Tammy Daybell, and said, "I'm going to burn some limbs in the backyard," the next day, right?
I believe that that text message was sent on the 9th that he said he
Right.
wanted to burn, yes,
Yeah.
burn limbs, yeah.
Right. So on the 8th, he's checking the wind. And on the 9th, he sends an email to his wife saying, I'm going to burn some limbs in the backyard, right?
Correct.
Okay. And then Rhode Island area code. Now, you don't know what kind of phones we're dealing with. These aren't like track phones, are they? Or do you know what kind of phones these are?
I believe they might actually be track phones.
Go ahead.
No, that's,
Oh, you believe they are all track phones, right?
I don't remember off the top of my head. I mean, so track phone is kind of a provider. So if you're asking like, is it an iPhone or an Android? I'm not,
Right.
yeah.
But the track phone, the way that works, and if you don't know, please tell me if you don't have knowledge of this, but the way the track phone works is you buy the phone for a period of 90 days. It expires and you could either buy another phone rather inexpensively, or you have to buy the adding the minutes thing. And there's no real discernible difference in the cost, right?
Correct. Yeah, you can keep the phone and change the number, correct?
Right. Or you can just get a different phone and same thing. And you buy that at, I don't want to give anybody publicity, but large retail stores that sell a lot of groceries and other things, right?
Yes.
You know what we're talking about.
Yes.
Okay. So if you're having an affair with somebody and you don't want to get discovered that you're having this affair with another woman while you're still married, it wouldn't be illogical for you to buy a number of phones. And as the phones expire, you just buy another phone to sort of protect yourself from being discovered that you're having this affair. Would that be fair?
Correct. I mean, in this
Okay.
situation, he's not buying phones. It's changed. It's the same phone. The IMEI number stayed the same on all of them. So
Right.
the device didn't change, but the phone number did. Yes.
Okay.
Same idea.
So that would be, he's trying, it's possible that what he's trying to do is he's trying to cover up the fact that he doesn't want to be discovered by his wife, that he's cheating on her, right?
Correct.
Okay. And Judge, if I can, ask the court again, the number for the summary of search activity with Lolly time with Lori Vallow, what that exhibit was again?
It's 184A.
If I have permission, Judge, may I have permission to publish?
You can publish that page, which is a printed copy of the PowerPoint presentation.
So again, we see the subject of Malachite and whoever is on Lolly time, whether it's Lori Vallow or whatever, is doing that, correct?
Correct.
Now, this is what is interesting to me on 7/21 of 2019. Okay?
Objection, Your Honor. Again, there's a narrative. I'd move to strike and counsel and ask that he ask a question.
Yeah.
I'll ask him.
It is sustained, and Mr. Pryor, please refrain from that. It's just
Okay.
questions.
All right. So 7/21 of 2019. And my notes seem to indicate that you said that was a short time after Lori Vallow and Alex Cox murdered Charles Vallow. Is that fair?
Yes, that would have been approximately 10 days after Charles's death.
Okay. And prior to Lori Vallow moving to Idaho, correct?
That's correct.
Okay. So you know from the facts, and you familiarized yourself with the Charles Vallow case, right?
That's correct.
And you know from the facts that at the time Charles Vallow was murdered, Lori Vallow was there, wasn't she?
At approximately the same time. I don't know the exact timing. I know she left
Right.
at a certain point, but I don't know exactly the time frame. Yes.
Well, you know that after the murder, that Lori Vallow was interviewed in front of the house right after the murder.
That's correct. Yes.
You also know that she left a little bit of time because prior to the murder, Tylee Ryan was present and so was JJ Vallow at the time, or at around the circumstances relating to the murder of Charles Vallow, correct?
Correct.
So it seems then that at least Tylee Ryan and JJ Vallow would have knowledge or at least information as it relates to the murder of Charles Vallow. Would that seem logical?
Yes, it would.
Okay. So if someone's looking and realizing that their children witnessed the murder of their father by their own brother, that's a motive for a number of things, right?
I suppose.
Okay. It's also a motive on 7/21 of 2019 to come up with a reason to get rid of a child if that child witnessed the murder of their stepfather, correct?
Potentially.
Okay, potentially?
I don't know if they saw that. I believe that Lori and the children left. There's, I think, if I understand right, there's a bit of discrepancy about if the kids were actually there
Right.
to witness the shooting, but I thought that they left prior to the actual shooting.
Well, you
But
did,
they listened to there was an argument, yes.
and
correct.
there's a discussion because part of the FBI and the officers down there interviewed witnesses who suggested both sides of that issue, correct?
Correct. I don't know if we know. I mean, Tylee obviously isn't here to ask, so we're not sure what exactly she saw at the
Yeah.
time.
So we don't know what JJ saw. We don't know what Tylee saw because the evidence goes both ways in terms of what exactly did they see in regards to the murder of Charles Vallow, right?
I believe Tylee was interviewed, and I don't recall what her interview stated,
Okay.
but I don't remember about JJ.
Okay. But you also know that one of Tylee's very close friends was interviewed and provided information about what Tylee said as well, right?
I don't remember that, but
Okay.
that makes sense. Yes.
Yeah. So then that's why there's some discussion because we don't know exactly where Tylee was when Alex Cox murdered Charles Vallow, right?
Correct.
Okay. So Lori Vallow, before she comes to Idaho on 7/21 of 2019, searches a life insurance policy for her children. Okay. Now there's no equal discussion I didn't see it and I went looked at the stuff. I didn't see anything where Chad Daybell talked about life insurance for the children. He didn't, did he?
No, sir.
And there's no email or search on let's kill 2 kids, right? By Chad Daybell?
No.
Okay. And would you agree with me that part of the rationale of bringing up Hiplos and James and Elena is because of the religious connotation, right?
Not necessarily the religious connotation. It just provides some context in other evidence because of the aliases, and it gets complicated with the names that they call each other.
Right.
So to see that they're being searched by these individuals and to provide context for later of
Oh.
where these names are coming from.
Okay. Now, so we have some references to religion, calling each other religious names. And you're aware that both of these folks have strong religious beliefs.
Yes, sir.
And you're aware Melanie Gibb has strong religious beliefs.
Yes, sir.
David Warwick has strong religious beliefs.
Yes, sir.
Zaluma Pastenes, Alex's wife, strong religious beliefs.
Yes.
In fact, the circle of all these people, there's repeated references to religion, right?
Absolutely.
Strong references to religion.
Yes.
Okay. So I guess what I'm kind of wondering, is it a bigger motive to kill 2 kids by their mother and brother to cover up the murder of a 4th husband? Or is it because they killed the kids because Chad, Lori, Melanie Gibb, and David Warwick and Zaluma Pastenes have strong religious beliefs? Which one is a greater motive to murder children?
Objection, Your Honor, argumentative.
Sustained.
9/30 of 2019. How to get the back seat out of a Jeep. And that's Lori Vallow, right?
Yes, sir.
There's nothing about Chad Daybell trying to figure out how to get the back seat out of a Jeep, right?
No, sir.
And I guess if a girlfriend asks you to help me get a tire because somebody wants to use the Jeep, that would explain why Chad was helping his girlfriend load and unload a tire, right?
Yes, sir.
Okay. Gilbert, Arizona News on the day that Brandon Boudreaux, and you've previously testified that Brandon Boudreaux, Chad Daybell is not criminally implicated in anything with Brandon Boudreaux, correct?
He's not being charged, correct, sir?
He's what?
He's not being charged.
Right,
in
not
Arizona,
being
correct,
charged, not
yes.
being pursued for anything for any reason. But
Objection, Your Honor. That misstates the testimony.
Sustained. And again, counsel, try to let the witness finish her response before you get into another question, please.
Your Honor, and I would move to strike counsel's last statement.
I'll strike that. I'll instruct the jurors not to consider that last statement.
okay. So your comment is Chad Daybell has not been charged. Is that fair?
Yes.
Okay, thank you. Did you see a likewise Google search on Chad Daybell's Google account that talked about Gilbert, Arizona on that day?
Not that I recall.
Okay. And then you're aware that that on 10/22 of 2019, are you aware that Lori Vallow was in Hawaii by herself with a friend?
Yes.
And you were aware that her friend was Audrey?
Yes, Audrey and maybe Melanie Boudreau. I know there was some shuffling there, but I don't remember the exact time frame. But
Right.
yes,
But they were, about 10/22 of 2019, Lori Vallow and a couple of friends went to Hawaii and I believe they were in Kauai, I remember. Is that fair?
I don't remember what island, but yes, that sounds fair.
But the purpose of them being there was to start the process of getting a wedding dress for Audrey Boudreau, right?
I do not know that. No, sir.
Okay. But the three of them were there, right?
Yes.
Okay. You just don't know why they were there and what they were doing there on that day, right?
Yeah, it seemed like kind of a spontaneous.
So if Audrey
Right.
Boudreau was looking for a wedding dress on 10/22 of 2009,
Your Honor, objection. Counsel's stating facts not in evidence.
Yeah, there's no Audrey Boudreau, Mr. Pryor.
I'm sorry, Judge.
Audrey Boudreau.
Baratori, Judge. I'm sorry. I said Boudreau. It's Baratori. I got the name wrong. No. Is that the correct name?
Audrey Baratiero or
Baratiero.
Melanie Boudreau. Yeah,
I got them backwards.
they both were in Hawaii, but yeah, I'm not sure which one you were.
With her.
Correct. I think some of them overlapped, but at different times. I don't know on 10/22 exactly off the top of my head now.
Right. And you don't know, and you don't have facts one way or the other as to whether or not on that particular day they were looking for wedding dresses, right?
I don't, other than that search, no.
Okay. Judge, I think that's all I have. Thank you.
All right. Ms. Blake, redirect.
Thank you, Your Honor. We'll start with the last question. You were asked about Audrey Baratario and searching for wedding dresses. Are you aware if Audrey's married?
At the time, I don't believe she was, no.
Anything in your investigation or records you reviewed that showed she was engaged?
I believe she'd mentioned, or I don't think she was actually married, no. I'm trying to remember now. I don't think she was.
And you were asked about the attempted shooting of Brandon Boudreau. And I think you indicated Chad has not been charged in that. Is that correct?
That's my understanding, yes.
And in relation to Charles Vallow, Chad has not been charged. Is that correct?
Yeah, I believe so, yes.
Are you still part of any active investigation in those cases?
Am I on to testify in those cases?
Are you assisting in any further investigation, if there is any going on?
No,
And those are being handled by agencies in Arizona, is that correct?
I believe so, yes.
So all you can say right now is that Chad hasn't been charged.
Yeah, I haven't really followed that portion of it, no, other than what was included in this investigation, yes.
You were asked about those Ned Schneider searches. Are you aware through your investigation who designated Charles as Ned?
I guess Lori calls Charles Ned is the first time where you sort of hear that on the body cam footage. Charles is relaying that Lori refers to him as Ned. I don't know where that name comes from, no. I don't know if she brought it up or if Chad gave her that name. I don't know how that worked.
And the searches from Chad were being done around the same time Charles is reporting that Lori's calling him Ned Schneider.
It's around the same time, yes.
You were asked about the potential for someone else to use Chad's email to do some searches.
Potentially, yes.
Did you find any searches in related to that email, to Chad's email regarding divorce or separation?
Not that I recall.
You were also asked about people changing phone numbers to hide an affair.
Yes,
Are there, in your experience, do people involved in criminal activity also switch phone numbers?
yes.
And then there was some talk about Melanie. Actually, let me back up. There was some extensive discussion regarding the killing of Charles Vallow and where JJ and Tylee were. Do you know where they were at the time Charles was actually shot?
I don't believe they were there. I believe the report said that Lori took the children to, I think they went to Burger King or something. But I don't know if that was corroborated or not.
And we'd talked about the phone attribution earlier, and with one of Chad's numbers, you'd made reference to attributing that number to him in part because of a mortuary call. Do you recall that?
Yes,
And that call to the mortuary, do you recall what day that took place?
I believe it's July 11th, 2019,
And when was Charles killed?
the same day.
And do you know where the mortuary was located that he placed that call to?
In Arizona, but I don't remember which city.
And Charles was killed in Arizona?
That's correct.
Then you were asked quite a bit about Melanie Gibb and David Warwick. Their names came up at least. Is that fair?
Yes.
Did Melanie, through your investigation, did you determine whether, or was there anything to indicate Melanie Gibb or David Warwick profited from JJ's death?
Judge, objection goes beyond the scope.
Overruled.
I did not learn of anything why they would benefit from JJ's death now.
Thank you. I have nothing further.
All right. I don't believe that opened any doors for additional recross. Did you have anything, Mr. Pryor?
Judge, I would have a couple subjects, but if the court's determination is that there's nothing open for recross, I'll defer to the court's wisdom.
All right, that'll conclude then the testimony of this witness. Practical Agent Heidemann, you are done testifying. Is this witness going to be recalled, do you believe?
She is going to be recalled by the state. I'm not sure if she's being recalled by the defense.
Not by the defense, Judge.
Okay, since you are going to be recalled, I'll just remind you, there is an exclusionary order in place. You're not permitted to discuss your testimony or review the testimony of other witnesses in the case in between now and the time that you're recalled. If you don't comply with that order, you may be prohibited from further testimony, so please comply with that.
Sure.
All right. You can go ahead and step down then, and I'll inquire of the state momentarily as to who they will be calling as their next witness. All right, who will the state call next?
And thank you, Your Honor. I'm just looking at the time. I think it's about 15 minutes to 10. The next witness, I believe, will be on the stand for quite some time. I'm not sure if the court would like to take a break now or how soon you wanted to take the mid-morning break.
My preference is to probably get started with this witness if they're a longer witness anyway, and then go for maybe another 30 minutes.
So trying to take a break at about 10:15.
I think so.
I will try to keep an eye on the clock for that. The next witness is Detective Duncan.
Okay. Go ahead and call your witness then.
Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you.
All right, the court will note that the witness, Detective Duncan, has been placed under oath. I am going to inquire as to whether or not you have viewed any of these trial proceedings because it is being live streamed. Have you listened in on any of the testimony that's been provided in trial since the case started?
I have not.
All right, thank you for that affirmation. With that, Ms. Blake, you can go ahead and inquire on direct if you'd like.
Thank you, Your Honor. Would you please spell your name for the record?
Good morning. My name is Nathan Duncan. It's Nathan. Last is Duncan, Duncan.
Where are you currently employed?
I'm currently employed with the Chandler Police Department in Chandler, Arizona.
What is your current title and or position?
I'm currently assigned to the robbery homicide unit as a detective.
How long have you been with that unit?
Robbery homicide unit, I've been there for 10 years.
Have you held other positions within the Chandler Police Department?
I have. I was hired with Chandler Police Department in year 2000, June of 2000, went to the academy, graduated in September. After graduating from the academy, I was a patrol officer for roughly 3 years. And after that, I went to the property crimes unit as a detective for approximately 11 years.
Do you have any specialized training in order to be a law enforcement officer?
So our training, like I stated, in June of 2000, we attend the Arizona Law Enforcement Academy as a program. I believe it was 16 weeks. And then afterwards, we attend a field training program with our own department. After that, every year, for the last almost 24 years, we go through advanced officer training, and we also do additional training in our specific area of expertise, if you would.
And were you working with the Chandler Police Department on July 11th of 2019?
I was.
Do you recall if you were on shift?
I was, yes.
And do you recall responding out to a report of a shooting?
Yes.
Do you recall where that was?
Report of the shooting on July 11th, 2019 happened at about 8:36 a.m. at the address of 5531 South Four Peaks Place in Chandler.
And you said the call came in about 8:36 a.m.?
Correct.
Were you one of the first responding law enforcement?
I was not.
Do you recall approximately when you responded out?
I would have arrived probably 20, 30 minutes after that original call.
When a call comes in of a shooting, who goes out first? Is it a patrol officer, a detective? Can you talk a little bit about that process?
So the immediate response to a call for service, in this case, a 911 call, a patrol officer will respond, or multiple patrol officers will respond for that call of service. They will get there, triage the situation, assist in any way they can, and then determine what they have. If additional resources are needed or investigative resources are needed from detectives, then detectives will be called in.
And in this case, did you learn who made that 911 call?
I did.
And who was that?
Alex Cox.
Did you learn what was reported?
Yes, Alex had contacted 911 and reported that he had shot his brother-in-law, Charles Vallow, in self-defense.
Prior to that, had you ever heard the name Charles Vallow?
I had not.
Had you ever heard the name Alex Cox?
I had not.
When you arrived on scene, were you given specific assignments?
Yes, in homicide investigations, we were given assignments. The case agent in this case was Detective Nathan Moffett, and he will assign tasks, if you would. In this particular case, I was assigned along with Detective Coons to document the crime scene.
And I think you've said, and that's common in a homicide investigation.
Yes, there are many multiple parts that go into a homicide investigation, interviews, scene processing. So we have a team of 6 at our particular unit, so we will divide up tasks.
At some point, did your role within the investigation change?
It did.
And can you talk a little bit about that?
So with the promotion of Detective Moffett in June of 2020, I was assigned to be the case agent in the death of Charles Vallow in June of 2020. However, I had done work prior to this date on this case.
And backing up to that July 11th, you're one of the scene detectives.
Yes.
Can you walk us through what you observed when you got there?
So as our job as a scene detective, we are there to document the scene, and we are assisted by crime scene technicians in this effort. So our first move that we'll make is we'll have the patrol officers who are present, who can provide some of the information to us as to what took place, give us a briefing. From that point, one of our crime scene technicians will enter and take overall photographs. And during this time, we will make observations of our own. The crime scene in this case was very simple relative to other crime scenes. The residence on Four Peaks Place, single-family residence. You enter the residence through a front door on the west of the residence. As you enter, you come into a small foyer, and then it opens up into a large living room. This one was unique in which there was a wood plank floor. There was no furniture in this living room. There was mirrors along the north side, an open window along the east side, mirrors on the wall on the south side, and mirrors on the wall on the west side. So as indicated, it was very sparse. There was no furniture at all. Inside, when making my observations, I noticed the body of a Caucasian male, later identified to be Charles Vallow, laying on the west side of this room. North of where he was laying, there was an aluminum baseball bat. And then a little bit north of this was a baseball cap that we had found out was worn by Charles earlier. To the west of Charles' body, there were two .45 caliber casings that were recovered. Also noted during this time was a bullet strike and a lodged bullet, or what we refer to as a projectile, that had lodged into the baseboard along the east side of that particular room.
And as you walk in, that's your initial scene observation.
Yes,
As part of the scene detective or just as part of the investigation, did you make observations regarding the body of Charles Vallow?
I did.
And I guess to back up a little bit, are you aware as to Charles' condition when first responding officers arrived?
When first responding officers arrived, he was pronounced dead by the Chandler Fire Department.
So upon your arrival, he'd already been pronounced dead.
That is correct.
Do you know if prior to your arrival, there were any life-saving measures taken?
There were reports in that Alex Cox had done CPR. And there was also indications, evidence left behind that the fire department had placed EKG or AED pads on Charles to determine whether life-saving efforts were needed.
And you said it was reported that Alex had done CPR. Did you observe any signs that would support CPR having been performed?
So in looking at Charles' body and the position that it was found, his head was to the north and his feet were to the south and his arms were to his side. I did see one wound consistent with a bullet wound in the front lower left quadrant of his torso. And that's the only wound that I noticed at the time. His shirt was cut open. He had a black t-shirt on. It was cut open by fire department. And as indicated, AED pads and EKG leads were put on for medical intervention. I did notice a lot of blood that was present on the floor or surrounding his body. Did not notice a lot of blood, which in my opinion, having given CPR and having been shot multiple times, I believe there should have been more blood.
And in relation to the CPR, had it been performed, you would have expected to see more blood?
I would have expected that, yes.
So based on your experience, you didn't see signs of CPR having been performed?
Correct.
And additional observations of Charles' body, were you able to see how many wounds he had initially?
So as indicated initially, it was just the one that I noticed with the front of his body, the lower left quadrant of his torso.
And at some point, did you notice any additional injuries to Charles' body?
I did.
And can you tell us what those were?
So in this case, in all homicide or death investigation cases, when the medical examiner is coming out to assist in these cases, the body is considered evidence, and we do not touch the body until the medical examiner arrives. They have jurisdiction over the body. So my initial observations were that one wound consistent with a bullet wound to the front lower left quadrant. After the medical examiner arrives, they take their own series of photographs, and we provide them with information that we know at the time. At that point, the medical examiner will then begin to examine or manipulate the body as they choose. During this time, the AED pad that was placed in the center of Charles's chest was removed, and an additional wound consistent with a bullet wound was noticed in the center of his chest. Additionally, when Charles's body was rolled, there were 2 additional wounds on his back consistent with bullet holes.
And when you talk about the 2 injuries to the front and the 2 to the back, did they appear to be, one being an entry wound, one being an exit wound, did they appear to be linked?
We try not to make that determination at the time. A lot of that goes in as far as entry, exits, and we also talk through the totality of the circumstances. In this case, Alex had mentioned that he had shot twice, so we would assume that they would be entrance wounds and exit wounds.
And so you talked about, Alex said he'd shot Charles twice, correct?
Correct.
Are you aware of what else Alex had claimed in relation to the shooting?
As indicated, he claimed that he had shot him in self-defense. He had indicated that he had the baseball bat, and Charles had struck Alex in the back of the head with the baseball bat and refused to drop the bat, and that's when he shot him.
And based on your observations, were you able to form any opinion in your training and experience as to where they would have been where Charles would have been in relation to the shooting?
Yes. So Alex had informed us that he was standing in the southwest corner of this particular living room, as described, and he was facing in a northeast direction, and he and Charles were face to face with each other. He indicated that he shot him twice standing up, and he shot him twice in the chest from a standing position.
And are you aware if you talked about the medical examiner's office showing up to take Charles' body?
Yes.
Do you know if an autopsy was ultimately conducted?
It was.
And are you aware if there was any determination made as to whether or not Charles would have been standing when both shots were fired?
So the 2 wounds, according to the medical examiner, the wound described in the center of the chest was front to back, exited his back, and it was slightly at a downward angle. The second wound that I'd mentioned, the lower left quadrant, that bullet traveled upward at a very steep angle, exiting the back of Charles's shoulder. When examining and observing the original scene, we had brought Alex back to do what's called a walkthrough to have him explain exactly where he was when all this took place. He indicated, like I stated, that he was standing and fired 2 shots standing, and while Charles was in front of him. Prior to Alex coming, we made the decision to cleaning up the blood that was left. And when we did clean up that blood, noticed a indention in the plate wood flooring that was near Charles's left shoulder, and that would be consistent with the exit wound on that back left. Also near Charles's left shoulder was a bullet or a projectile that was present when first responders arrived. So based on the autopsy reports and the scene evidence, the first shot fired on Charles would have been the center of his chest, exiting the back and then lodging in the baseboard. The second shot fired at Charles would have been while he was laying down on the ground.
And you talked about this room either not having furniture, being very sparsely furnished. Based on your investigation, were you able to determine whether or not a struggle had occurred?
Obviously, one thing we look at, we're trying to determine and prove or disprove the self-defense claim. And with the room being sparsely furnished, we were unable to see if anything was knocked over, broken, anything like that. Charles did have some wounds or some abrasions to his knees. He was wearing shorts at the time. So he had some abrasions to his knees and also some scrapes on his hands or arms, some minor scrapes there. So those two things would indicate that a struggle took place, but other than that, there was nothing that would indicate that.
And you talked about, we've talked a little bit about the blood in relation to at least the CPR. Was there any additional blood located in the residence?
There was.
And can you talk a little bit about that?
So Alex had indicated that he had washed his hands in the sink at the residence. The only other location that blood was present, besides underneath Charles's body, was on the faucet in the kitchen sink.
And was this, based on the report of the shooting, was this investigated as a homicide?
Yes, it was.
And we talked a little bit about, you ended up taking over the case or being assigned the case agent or the lead on this in June of 2020.
Correct.
You initially responded out on this July 11th date of 2019. Did you continue to work on the case after July 11th, 2019?
Unfortunately, right after this homicide, I had another homicide, so I did not work on it for a period of time. I then picked up this case and assisted Detective Moffett roughly January of 2020 with looking at phone extractions and iCloud information.
And when you picked up again in January, you talked about you started looking at phone extractions.
Correct.
As part of that, did you end up seeking some search warrants?
I did.
And was one of the devices that you reviewed the content of Charles Vallow's phone?
Yes, it was.
And do you recall how you came to be in possession of Charles Vallow's phone?
Yes. Through our investigation, we had determined that Charles's phone was pretty much the catalyst of an argument that occurred between Lori and Charles on this day. After the shooting, or shortly after the shooting, Lori had left the house, taking Charles's phone with her. She would later return that phone to detectives, and that phone was now in our possession, and an extraction was done on that actual device.
And did you in fact review the extraction?
I did.
And in reviewing the extraction, was there a significant amount of information contained on that device?
Yes, there is.
And as you went through it, did you look at things that seemed to have significance to you in relation to the investigation?
Yes.
And in preparation of your testimony today, did you prepare an exhibit related to that content?
I did.
Do you believe that it would aid in your testimony today?
Absolutely.
Do you believe it would aid the jurors in understanding the evidence and information?
Yes.
Your Honor, I'm going to ask that the witness be shown what's been marked as State's Exhibit 49. I do have a copy for counsel and a courtesy copy for the court as well. Again, as with some of the last exhibits from the state, these are printouts of a PowerPoint. The PowerPoint itself is on a jump drive.
Council, these are three different exhibits, right? Four? Looks like they're all the same.
I believe I believe there are some other exhibits. That should all be one exhibit. Or,
And is it your position I get one of these?
yes, there would be a copy for you.
Thank you. Thank you, officer.
And Detective, I would ask you to just look through those if you could.
Okay. Okay.
Do those appear to be an accurate depiction of the PowerPoint that you prepared?
They do.
And again, they are taken from an extraction from Charles Vallow's cell phone. Is that correct?
That is correct.
Did that include looking at an iCloud account?
It does include an iCloud account. Yes.
And does it include messages or other content from that phone as well?
Yes, it does.
Your Honor, I would move for the admission of State's Exhibit 49.
No objection, Judge.
All right, exhibit 49 will be admitted, and again, this will be actually the PowerPoint on a digital format, and the court has reviewed a printed copy of that. Ms. Blake, with that being introduced, if you'd like, I think this would be a good time to stop for the morning recess before we start with the publishing of this, if that's where you're headed.
That is where I'm headed next, Your Honor.
Okay, let's go ahead and take our mid-morning recess then, 30-minute recess, and we will be back on the record after that.
Thank you.
Thank you.
All rise, please.
Thank you. Please be seated. All right, I'll request the bailiffs now bring the jurors back in, please.
All right. The jury is present and accounted for.
All right, thank you. Please be seated. All right, we are back on the record now on KCR 22-21-1623, State of Idaho versus Chad Daybell. Just concluded our mid-morning recess. And just before that, Ms. Blake, Exhibit 49 had been admitted. Detective Duncan is still on the stand under oath, and if you'd like to continue your direct, you may do that.
Thank you, Your Honor. The state would ask to publish State's Exhibit 49.
All right, you are allowed to do that.
And Detective Duncan, we've already talked about, but just to remind the jurors, the information contained in this PowerPoint was from Charles Vallow's phone. Is that correct?
That is correct.
And on this slide, can you please read this into the record?
Yes, I can. Hello, Chad. I hope you are doing well. This is Charles Vallow from Arizona. We really enjoyed having you stay with us back in November when you came to the Preparing a People conference. I appreciated you taking the time to talk to me about the book I've been working on. Well, more than 6 months later, I still haven't made much progress on it, but I feel an urgency to get it done. As the managing partner of Right Planning Group, I'm going to have the opportunity to speak at various conventions beginning in the fall. But everyone says I need to have a book available that summarized my life and shares the principles I follow. So I will cut to the chase. I'm willing to pay you well to help me get this book into shape as my ghostwriter. I really liked your autobiography and the tone you took in sharing experiences without preaching. Is there any way you could come here for a couple of days and help me get the book underway? I feel talking in person would be much more valuable than a phone call or video chat, mainly because I would like you to read through some of my journals and explain to me how the publishing industry works. It would help me know whether I truly have a book in me and whether you want to team up on it. I played minor league baseball and have plenty of stories that my audience could relate to, along with the knowledge I've gained running my own company. So I do feel the book would contain valuable information even beyond the convention circuit. I'm out of town until Sunday, but I would gladly fly you down here next week before the holiday and cover your expenses. You could stay in our guest room like before, or in a hotel if you prefer. I hate to take you away from your family, but I know this book is vital to my speaking success. I understand if you don't want to take part in the project, but I would definitely make it worth your time. With admiration, Charles.
And through your investigation, what did you learn in relation to this email or this message, if anything?
So this particular message was a document that, in looking at Charles' additional phone records, he had indicated to Lori, as well as to Lori's brother, Adam Cox, that he had found this on Lori's computer. This would have been the first letter to which he mentioned Chad or suspected Lori of having an affair with Chad.
And at some point, were you able to learn if this particular email was associated with a specific email address?
It was not.
And did you learn whether or not this was actually written by Charles?
All indications in Charles's phone and content that when he's sending this to Adam and to Lori is this was fictitious and this was not created by him.
And just to back up a little bit, as you're going through these extractions, were you aware of any other ongoing investigations that were related to what you were looking into?
Yes, in January of 2020, when going through these extractions, I was aware of multiple investigations. I was aware of the disappearance of JJ and Tylee. I was also aware of the attempted or the shooting on Tammy Daybell, as well as Tammy Daybell's death. In addition to that, there is another case in Gilbert, Arizona with the attempted shooting at Brandon Boudreaux.
And as you were looking through this phone extraction as well as others, were you also paying attention or looking for anything in relation to those other investigations that you thought could be helpful?
Yes, while going through these records, this particular record and subsequent records, I was mainly focusing on the Charles Vallow investigation, but anything that I saw that could have been pertinent to the locating JJ and Tylee and the other investigations, I would pass that along to other investigators in Idaho.
And as we talk through this, just to make clear to the jury, do you know did Lori have a brother named Adam Cox?
Yes, she did.
Did he also have a brother named Alex Cox, or did she also have a brother named Alex Cox?
Yes, she did.
Was Adam Cox at any point a suspect in relation to this investigation?
He was not.
Was he someone that you learned had communications with Charles?
Yes.
Was Alex Cox a suspect?
Yes, he was.
Thank you. And if we look at the next slide, can you read these messages into the record?
Yeah, so these are messages that were found on Charles Vallow's phone extractions. The first message is from Charles to Lori, dated June 29, 2019 at 5:51 a.m. Is he with whom you're having an affair? He did not stay with us in Arizona in November. Who are you lying to now? Trying to destroy another family? You're evil. Period. I may take JJ back to Houston unless you have a great explanation for all of this. I will not let him be a party to your apostasy. The next message from Charles to Lori, June 29, 2019 at 6:04 a.m. Just so you know, I have Tammy, Chad's wife, email address. I will send a copy of my email you sent to KK Walker. Tammy will know what you're up to. You better explain. Charles then writes, June 29, 2019 at 6:10 a.m. I now have Tammy Daybell's cell number. I'll text her a copy of the letter and an explanation of what you're up to. You have till noon your time to explain, or I'm sending via text and email to her. And finally, Charles to Lori on June 29th at 6:55 a.m. I'm sure you're up by now. You have until 10 a.m. your time to respond, or I send the emails and texts to Tammy.
And at the time these emails are being exchanged, Charles is still alive, obviously,
Yes, he is.
and Tammy Daybell is still alive.
Yes,
And you had recovered that previous email that we talked about.
correct.
And that email appears to have been written by someone holding themselves out to be Charles to Chad Daybell.
Correct.
Through your investigation, did you learn whether or not Charles actually made contact or attempted to make contact with Tammy?
I did, yes.
And what did you learn in relation to that?
So again, looking at Charles' phone, there is indication that Charles had addressed emails to Tammy Daybell and sent those emails to her.
Do you know, or did you learn whether or not Tammy ever looked at those or received them?
No indication that she looked at them or received them.
And looking to the next slide.
Once again, Charles to Lori, June 29th, 12:23 p.m. Just so you know, and Chad know, I am going to talk to Tammy in person if I have to. I've already emailed and texted her, your game is up. Charles sends another message to Lori the same day at 5:04 p.m. Please stop spending money on the credit cards. I appreciate it.
And this is a continuation, it appears, from the conversation we were just looking at in the previous slide.
Yes, it is.
And we talked about any indication that Charles did in fact email Tammy. Did you uncover anything in your investigation regarding whether or not he ever attempted to visit her in person?
I did not.
And so we don't know, no evidence that he did.
Correct.
And looking at this date of June 29th, this is just a few weeks before Charles is shot and killed. Is that correct?
Correct.
And turning to the next slide, when we talk about the email, is this the one you were referencing?
Yes, it is.
And could you read this into the record?
So the first email from Charles Vallow to Tammy Daybell, and it was sent to tdaybell@sugarsalem.com on June 29th, 2019 at 9:06 is the stamp that was on the email. Tammy, my name is Charles Vallow. I have some vital and disturbing information regarding your husband and my wife, Lori. This is your work email, so I'll wait to send you the evidence that is very disturbing. You may call or email me from the address where you can receive the information. I apologize to be the one sending this, but something has to be done. I feel it's best if I shed some light on this issue. Regards, Charles Vallow, 714-853-5005.
And it looks like there's another one, or this may be the subject line. Could you read that next one?
Correct. The email from Charles to Tammy Daybell, coming from Charles Wright Planning Group email to another email for Tammy is tammy.daybell@gmail.com, June 30th. So the following day, 2019 at 10:16 a.m. The subject line on this email was your husband and my wife, and then the body are having an affair. Her name is Lori Vallow. I've got definite proof or definitive proof. If you care to see it, contact me and I'll share it with you. It's devastating, I know, but the truth needs to be shown. Charles Vallow.
And again, to be clear, through your investigation, you were never able to determine, or you did not learn whether or not Tammy actually saw these emails.
Correct.
And then can you talk about what we're seeing on this slide here?
This is another email from Charles Vallow, a Gmail account to chad.daybell@gmail.com, sent 6/29/2019 at 9:32 a.m. The email reads, Chad, I'm Lori's husband, but I gathered you already knew this. She sent an email yesterday, supposedly written by me, to KK Walker, inviting you to Arizona next week and to ghostwrite a book I'm supposedly working on. It's preposterous. I happened to run across it as she left her computer at our Houston home. I am not paying anybody for anything, and I am not writing a book. Either you or Lori need to tell me what's going on, or this will be exposed for all to see. Regards, Charles Vallow, 714-853-5005. And does your wife know you have several of Lori's dance videos? Explain how that is in any way appropriate. She sent them to you at your request in January, Charles.
And relating back to that first email, when we talk about the belief it wasn't drafted by Charles, did this play into why you believed that it was not drafted by him?
Yes, it did.
Is there anything else about this that drew your attention?
So this, obviously Charles mentions a KK Walker, an email sent to KK Walker. So through this information, we were able to locate the KK Walker account of KK Walker 75 at yahoo.com.
And ultimately, were you able to link that KK Walker email to any particular person?
Yes,
And who was that?
Lori Vallow.
And if we look at this next slide, if you can tell us a little bit about what we're seeing and read that.
So also again on the actual Charles Vallow's device and the extraction from that device is a message from Charles to Lori on June 30th, 2019 at 8:42. Lori, I know you don't care much. I know you don't much care how I feel, but just imagine this. How could my actions or breaking your heart result in what you've done? You accuse me of infidelity, but it's you who have been having an affair. It just keeps killing me. Maybe that's your goal. How can you live with yourself destroying our life, Mel and Brandon's, probably Mel and Brendan too. Now add Chad Daybell family and you've got a home run. The fact that you continue to go to the temple after all you've done shocks even me. There really is something wrong with you. I really don't want to do what I have to do, but you have to be exposed for what you really are. You won't even deny it or talk to me as to your reasons. That's what's amazing to me. You could allay some of what's about to happen, but I don't think you will. Lying has become second nature to you. You have been impressive in blaming me for all that's happened. You have destroyed me. I've never been lower in my life. It's you that has done it. Please tell me why, please. I will slow or minimize what's about to happen. It's you who has caused it. We have a son to raise, but that's all we have in common. I will work with you in his best interest and will be there Monday evening. You owe me an apology for all the false accusations you've made. You know I've been entirely faithful to you since the first day we met. I deserve an apology from you. Please respect that much.
So this message is sent around the same time the messages are being sent to Chad confronting him about the affair, correct?
Correct.
And this is also sent around the same time Charles reaches out to Tammy.
Correct.
Through your investigation, did you learn whether or not there were any divorce proceedings that had been going on between Charles and Lori?
I was not aware of any.
Do you know through your investigation, did you learn if at times they had separated?
There was indication that they were separating, living in different locations, yes.
And on this next slide, can you talk a little bit about what we're seeing here and then read these into the record?
Yes, once again, additional messages found on Charles Vallow's device. Charles to Lori, July 1st, 2019, 10:31. I'm going to Idaho first to meet with Tammy Daybell. Lori to Charles, July 1st, 2019, 10:32 a.m. She won't see you. She is my friend. She won't listen to you. Go ahead. You're ridiculous. Are you coming to JJ for the 4th or not? Charles to Lori, July 1st, 2019 at 10:37 a.m. Then you tell me why you used my name and a fictitious email to send a BS email about a book I am having him ghostwrite for me. It's fraud and a lie. There's no other reason for it other than to get him to Arizona or AZ, get him in AZ and have an excuse for his wife. Charles to Lori, July 1st, 2019, 10:38 a.m. You did this. I had nothing to do with it, and you know it. Also, he did not stay with us in November. I will find out.
Did you learn what that reference of he did not stay with us in November was in regards to?
That was in regards to the letter found on the Chad's device, and then also another, what is a KK Walker email where Chad was being requested to come to Houston. I believe those were the two.
And one of the emails referenced him being in Arizona the previous November,
Correct.
and that would have been November of 2018.
Correct.
And there's also a response there from Lori saying she's friends with Tammy.
Yes,
Did you also review data in relation to devices or accounts linked to Lori Vallow?
I did.
In your review of those, did you find any communications between Lori and Tammy?
I did not.
Any indication that they were friends in those devices, at least?
No,
Did you find communications between Lori and Chad?
I did.
And on this next slide, can you talk a little bit about what we're seeing here and then read it into the record?
So once again, in Charles Vallow's actual phone extraction, the day of his murder, and these text messages take place between 7:35 a.m. and 7:37 a.m. between Charles and Adam Cox, who was Lori's brother. Charles sent Adam a text, "Al is here." Adam responded, "At Lori's?" Adam responds, "Really? I wonder why he never called me back." Adam responds, "They are planning something." Charles responded, "Absolutely." Adam responded, "I was supposed to spend the night at his house last night. She probably blocked that." Charles responds, "What you do is up to you."
And up until this slide, or actually, excuse me, just the slide before this, we're talking the beginning of July when he and Lori are exchanging those messages. Is that correct?
So from June 29th was when that letter was discovered and the communication starts. So up until then, yeah, or from that day on, yes.
And you indicated this is the day that Charles is killed when these messages are exchanged.
Yes, it was.
And again, Adam Cox is one of Lori's brothers,
Yes,
and he was not a suspect, correct?
correct.
And when we look at the time that these are exchanged, it's early in the morning.
Yes.
Were there any additional communications on Charles' phone after this?
There were not.
Charles was shot and killed shortly after these messages were exchanged.
Correct.
And we've talked a little bit about that you reviewed. And actually, I apologize. I'll get this submitted to the court first. And we've already discussed a little bit that as part of your investigation, you also reviewed some accounts associated with Lori Vallow.
Yes,
Did those include some iCloud accounts?
2 of them were yes.
And do you recall what those iCloud accounts were?
So the first iCloud account that Lori used was Lori for style, the number 4. So Lori, the number 4 style at iCloud.com. And from that extraction or from that information, we were able to determine a second iCloud that was created, which is lollytime at iCloud.com.
And in reviewing and specifically looking to that Lori for style, was there a significant amount of information located on that device?
Yes, there
Or,
was.
excuse me, on that account or linked to it?
Yes, there is.
And from that information, and then also same question with the lolly time, was there a significant amount of information?
Yes,
And in preparation for your testimony today, did you prepare an exhibit?
I did.
And does that exhibit pull some of the information that caught your attention?
Yes, it does.
And given the amount of information within those accounts, do you believe that it would aid you in your testimony today?
It sure would.
Do you believe it would aid the jury in understanding the evidence as well?
Yes, it would.
Your Honor, I'm going to ask that the witness be shown State's Exhibit 48. I believe defense has a copy as well. And similarly, these are printouts of a PowerPoint, so we have an actual jump drive, but as a courtesy, we printed these out.
I already have a copy. No objection, Judge.
Okay, I'll just quickly review them.
And Detective Duncan, if you could look through those as well.
All right, I'll note there is no objection to the offered Exhibit 48. The court will admit the exhibit, noting again, the actual exhibit's a PowerPoint XLS digital file, and what the court's reviewed is a print-off version of that.
Okay.
And does that appear to be an accurate representation of the PowerPoint?
It does.
Thank you. Your Honor, now that it's been admitted, the state would ask to publish.
You may publish it.
And you talked about the first iCloud account. What are we seeing on this particular slide?
So in this particular slide, I'm showing you the Lori for style at iCloud.com account name, username. Under this account, these 4 numbers are registered under that account.
And as you went through the account, is that where you located these numbers?
Yes,
And so these are numbers that ended up being associated with Lori Vallow, is that correct?
that is correct.
And looking at the next slide, can you tell us what we're seeing here and then read the messages into the record?
Yeah, so on the iCloud account, Lori for style, the following messages were seen between Lori Vallow and Alex Cox. On 3/9/2019 at 11:27 hours, Lori sent Alex a text that says, apparently it is tied to Ned being gone. There's an emoji in there, but the emoji is not included. Hopefully today or tomorrow. On 3/10/2019 at 8:41 in the morning, Alex sent Lori a message. Love you too. Have fun and get rid of Ned already. 3/26/2019, at 17:36 hours, Alex sent Lori a message. Ned is still alive, just confirmed. 3:26, 2019 at 18:17 or 6:17 PM. Lori sends Alex a message. It's not Ned, and it's a new one.
What about those messages caught your attention?
So in the weeks and months following the death of Charles Vallow, we received information that Charles was possibly killed by Alex because he was a dark spirit or a zombie. The name Ned is a name that even Charles would tell people that Lori was referring to him as. So the name Ned is the dark spirit's name that was given to Charles Vallow.
And in that last message, we see reference to it's not Ned, it's a new one. Did you learn anything in relation to what that message may have been referencing?
To me, and
Judge, I'm going to object. That calls for speculation.
I'll sustain that.
Through the investigation, you reviewed other phone records.
yes,
And did you discuss the investigation with other individuals involved in it?
yes,
And did you review reports and interviews?
yes,
And based on your review of that through your investigation, were you able to make a determination as to what that may have been referencing?
yes.
Judge, and I'm going to renew my objection that it's speculation.
And Your Honor, if I may respond.
Go ahead, Ms. Blake.
Your Honor, I think under the collective knowledge doctrine, the officer's already established that if he can answer from his investigation what he believed it to mean, and it in relation to, although I haven't heard it, any hearsay, I think under the collective knowledge doctrine, it's not being offered for the truth of the matter. It's being offered as to what the officer determined in the investigation.
All right, well, with
Ju-
your, go ahead, Mr. Pryor.
May I
Yes.
respond? Judge, using that notion that it's as part of the investigation, it still calls for this officer to make a guess as to exactly what is meant by a particular phrase. So regardless of the investigation, regardless of whether he's looked at documents, he's still guessing. He's speculating, he's hunching, and he's not able to do that, and he's not allowed to do that.
All right, well, there's been some additional foundation laid. At this point, I am still going to continue to sustain the objection, just looking back at the question, which was whether or not the witness was able to make a determination as to what that may have been referencing. So I do think it's speculative at this point, Ms. Blake. Any additional foundation you could lay may change that.
Through your investigation, did you learn if Charles was designated by any other names?
Yes.
And what were those names?
Garrett and Hiplo.
And based on that, what was your belief with regard to it's a new one?
A new entity or a new dark spirit.
Thank you. And looking at this next slide, can you tell us what we're seeing here and then read the messages into the record?
So on the Lori for Style account, you see messages between Nicole Earl and Lori Vallow. These took place on 10/19 of 2019. At 9:18 in the morning, Nicole sent Lori a message. I'm not sure if you heard, but Chad's wife died last night. Lori responded at 9:33 a.m. Oh my gosh, I did not hear that. I'm in Hawaii and it's 6 a.m. Lori responded to Nicole at 9:34 in the morning. Do you know what happened? Nicole responded to Lori at 9:37. Yes, she awoke in the night coughing, threw up, collapsed, and passed away.
Through your investigation, did you learn on what day Tammy Daybell was pronounced dead?
Yes,
And what day was that?
October 19th, 2019.
So the same day these messages are exchanged.
Yes.
And we talked before that as you were looking through these, you were also cognizant of some other active investigations.
Correct.
Did you pass this information along to other law enforcement?
Yes.
And looking at the next slide, can you tell us what we're seeing here and then read it into the record?
Once again, these are messages between Melanie Gibb and Lori Vallow on the Lori for Style account on 10/19/2019. Melanie Gibb sent Lori a message at 1:16 p.m. I heard what happened to Chad's wife. Oh my gosh. Lori responded to Melanie at 1:18. Hello, what?
So on that last slide, we saw communications between Lori and Nicole Earl that took place in the morning hours of October 19th, correct?
Correct.
And now on this slide, later in the day, these are messages between Melanie Gibb and Lori Vallow.
Yes.
And what was it about these messages that caught your attention?
What caught my attention is the communication between Melanie Gibb and Lori Vallow, indicating that Lori was unaware that Tammy had passed away.
And that's even though there were the messages with Nicole Earl earlier in the day.
Yes.
And on the next slide, can you tell us what we're seeing and then read it into the record?
So on the Lori for Style account, on November 22nd, 2019, a text message is present from Lori Vallow to Colby Ryan, who is Lori's son. I text Ty to send it, but I haven't heard back yet. She will probably just do it before she tells me. Hope you got the Venmo. Ty said she sent it late. I'll call you when I get a break. Hope you're having a great day. I love you so much.
And in this message, were you, based on your investigation, did you know who Ty was that they were referring to?
Yes.
And who was that?
Kylie Ryan.
Did you learn when the last known sighting of Tylee was?
I believe it was the beginning of September 2019.
So this message is sent months after the last known sighting.
Yes.
And then you had indicated you also looked at another iCloud account.
Yes. So from the Lori for Style account led us to the lollytime@icloud.com. This information provided indicated that this particular account was created on July 1st, 2019. And the cell phone numbers listed are the numbers that are attached to that account.
So this particular account was created just 10 days before Charles is killed.
Yes.
And again, during this time, Tammy is still alive. Is that correct?
Yes.
Turning to the next slide, can you tell us what we're seeing here and then read it into the record?
Yes, this is communication found on this iCloud account between Lori Vallow and Alex Cox. On July 9th, 2019 at 1:49 p.m., Lori sent Alex a message stating, "So the plot thickens. Call me when you can." She sends another message to Lori, or another message to Alex Cox, 7/9/2019 at 9:50 p.m. Getting sleepy, so I'm going to need you to stay close to me the next couple days. Mel too. She can't go to Utah. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you.
And when these messages are copied over, do you copy them over as written?
Yes, I do.
So some may contain spelling errors,
Correct.
and the only difference is you did not include the emojis.
Correct.
What is it about these messages that stuck out to you?
This is 2 days before Charles would have died. Also, in looking at Charles Vallow's account, Charles was talking with Adam Cox about planning some sort of intervention, if you would, and talking to Lori about her her radical beliefs and the letters that he had found. So this stood out to me as some sort of plan that was taking place.
And again, this is just 2 days before Alex shoots and kills Charles Vallow.
Yes.
Were you able to determine who the Mel is that's being referenced in that second text?
That is Melanie Boudreau.
And who is she in relation to Lori Vallow?
That is Lori's niece.
And then moving to the next slide, can you tell us what we're seeing here and then read the messages into the record?
So what you're seeing here is oftentimes in what appears in an iCloud or what doesn't appear in an iCloud, you can capture in an actual phone record. Phone records and phone extractions are different. Phone extraction it's a copy of the actual device, where a phone record or a phone, they call them call detail records, are actual phone calls, text messages that are sent, and records are retained by the actual phone carrier. So in looking at a timeline of Charles Vallow's death, I was able to look at Lori Vallow's phone call detail records, and I noticed that there were phone or messages, text messages between Lori and Chad the day of Charles Vallow's murder. The times are at 6:12 a.m., 7:01 a.m., and 7:33 a.m. There is a record that this text occurred, but there's no content of what the actual text is.
And through your investigation, were you able to determine a span of time in which you believe Charles Vallow to have been shot?
Yes.
And when was that?
Based on our investigation, you looked at the record of Adam Cox and the last message sent by Chad and Adam, 7:37. So he arrives at the residence based on location data on Chad's phone.
And sorry to interrupt. I think you said Chad's phone. Do you
Sorry,
mean
I
Charles?
apologize. On Charles' phone. So Charles Vallow had location data on his phone, so it shows when he arrives. So it was around that 7:30 timeframe that Charles arrived at the Four Peaks address, and then obviously the call placed by Alex Cox at 8:36 indicating the shot. So somewhere between the 7:30 and 8:30 timeframe.
And so these messages with Chad are essentially stopped just before Charles arrives or around the same time.
Correct.
And then turning to the next slide, can you tell us what we're seeing here and then read them into the record?
So these are text messages between Lori Vallow and Chad Daybell, and the text messages were on July 18th, 2019. Lori sent Chad a message. I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to? Brandon or probably Kay? He left nothing for JJ. Chad responded to Lori, wow, that's terrible. There's no way to find out. Lori responded to Chad, I might be able to see when I get his computer on Sunday. I could check the emails sent to the insurance company. It will show change of beneficiary. He must have done it recently. Chad sent Lori a message. It seemed you would have had to agree to the change. Maybe your name was forged. You should have a good paper trail to prove it.
And then going to the next slide, is this a continuation of that conversation?
Yes, it is.
Would you please read those into the record?
Chad sent Lori a message stating, I love you. This is terrible, but it is probably another step in bringing down the Gadiantons, especially Brandon. Lori sent Chad a message to Chad. Nope, he can change it anytime he wants. He's the agent and anyone can change their beneficiary anytime with their own signature. I'm thinking it must be Kay. Chad sent a message to Lori. It will be interesting if it got changed after he had 2 bullets in his chest.
So these messages were exchanged just 7 days after Charles was shot and killed.
Correct.
What was it about these messages that stood out to you?
Obviously, what stood out is the Lori's concern with beneficiary money from a life insurance policy that she felt was coming to her after Charles's death.
And at the time these messages were exchanged, had Arizona publicly released how, or if you recall, had they released how Charles had been killed?
I don't recall.
But it's just 7 days after.
Correct.
And the indication to you was at the time Charles was killed, Lori would have believed she was getting insurance money.
Yes.
Did it also appear Chad would have believed that?
Judge objection calls for speculation.
Sustain.
Looking at the next slide, can you tell us what we're seeing here and read it into the record?
So this is another message on the Lolly time, I believe. Lori Vallow to Chad Daybell, 7/18/2019 at 12:19 hours. Lori says, so I talked to the insurance company. He changed it in March, so it was probably Ned before we got rid of him. They can't tell me to who, of course, but it's done. I still get the $4,000 a month from SS.
Did you learn through your investigation what the SS stood for?
Yes,
And what was that?
Social Security.
And did you learn through the investigation whether or not Lori was getting Social Security money or if her kids were?
Yes, she was. Yes.
And looking at this next one, can you tell us what we're seeing here and read it into the record?
This is a message from Chad to Lori on 7/26/2019 at 8:13 p.m. Tonight I figured out who I feel like. I'm a grown-up version of Harry Potter who has to live with the Dudleys in his little space under the stairs. Every few weeks I get to escape and have amazing adventures with my goddess lover. But then I have to return to my place under the stairs feeling trapped, but I sense permanent freedom is coming.
And this message would have been just 15 days after Charles' death.
Yes,
And was Tammy Daybell still alive at this time?
yes.
And then turning to the next message, if you could let us know what we're seeing here and then read it into the record.
So on 7/30/2019, Chad sent a message to Lori. An SMS message is just a text message that read, I got the inspiration to go back to my original death percentages that help us track Charles, Ned, etc. Tammy is very close. Her percentage has fallen steadily since Hiplos left. It is encouraging.
And through your investigation, I think you've already talked to us about it, but did you learn who Ned and Hiplos were referring to?
Yes.
And who was that?
And those were dark spirits that Ned and Hiplos and Garrett were dark spirit names referring to Charles Vallow.
And in this, there's reference to helped us, correct?
That's what I see, yes.
And this was from Chad to Lori?
Yes.
And then on this next slide, can you tell us what we're seeing here and then read it into the record?
So on this account was a text messages between Alex Cox and Lori Vallow, September 3rd, 2019 at 10:02 a.m. Alex to Lori, network name is anti-layman. PW is too many kids. Lori to Alex, funny.
And through the investigation, did you learn the last known sighting of Tylee was around September 8th?
Correct.
And the last known sighting of JJ was around September 22nd?
Correct.
And this message was sent on September 3rd.
Yes, it was.
So when the kids were still around.
Yes.
Your Honor, that exhibit is ready to be submitted to the court.
Very well. Thank you, Ms. Blake.
As part of your investigation, did you also review content from an individual named Zulema Pastenis's phone?
Yes, I did.
And you've already referenced and talked about looking into content on Lori's iCloud accounts, correct?
Correct.
And we just saw some of that.
Yes.
In looking at Zulema's phone and some of the iCloud accounts, did you end up creating another exhibit?
I did. Yes.
And again, given was the content of Zulema's phone voluminous?
It was. Yes.
And were you able to determine certain messages that you felt had evidentiary or that you felt were relevant to today's proceedings?
I did.
Do you believe that they would assist you in your testimony today?
Yes,
Do you believe they would assist the jury in understanding the evidence as well?
they would.
Your Honor, I'm going to ask that the witness be shown State's Exhibit 51. And similar to the last, these are printouts of a PowerPoint presentation. The actual exhibit would be a jump drive.
Very well.
And Detective Duncan, would you just look through those?
Okay.
Do those appear to be an accurate representation of the PowerPoint you created?
They are.
Your Honor, the state would move for admission of State's Exhibit 51.
No objection, Judge.
All right, Exhibit 51 is admitted, and again, that is the digital file on the thumb drive. The court has received a printed copy as well.
And backing up a little bit, in your investigation, because we've used the name Zulema Pastenis.
Yes.
Through your investigation, did you learn who Zulema Pastenis is?
Yes. Through our investigation, we learned that Zulema Pastenis was a friend of Lori Ballos.
And do you know if Zulema Pastenis eventually was married to someone related to Lori?
She was. Eventually, she would marry Alex Cox.
And we talked a little bit about Ned and dark spirits. Did those kind of things come up through your investigation?
Yes, they did.
And in looking in Zulema's phone, was there reference to things of that nature?
Yes, there were.
Your Honor, I would ask permission to publish State's Exhibit 51.
You may.
And looking at this slide, can you tell us what we're seeing and then read it into the record?
Yes, so on Zulema Pastena's phone, an extraction that was actually done by the Gilbert Police Department. I reviewed this phone content and I saw messages between Lori and Zulema. So on May 29th, 2019 at 10:32 a.m., Lori sent Zulema a message that read, "Perfect. I found out there are 4. One is a level 4 entity. His name is Hiplos. The H is silent. The other 3 are level 3s. Let's do this." And the following message from Lori to Zulema, June 2nd, 2019 at 11:54 a.m. "Yes, it does. Let's put some fire energy towards Hiplos now. He is driving now, and today is the day. I can do it spiritually. Let's go to him and hover over the truck till we do it. Are you ready?"
And looking at the next slide, if you could tell us what we're seeing here and read these messages into the record.
So the messages continue. July 2nd, 2019 at 7:52 p.m. Zulema sends Lori a message that states, "Also, I was given instructions today to rip, tear, or burn the aura of Hiplos to let the body energy out so he can't re-enter." There's a message from Chad Daybell to Zulema on July 2nd, 2019 at 8:35 p.m. "I am very happy to find out these estates. You and Lolo have doing amazing work. Mother Earth is so grateful to you both. Thank you as well for your help with Hiplos. He is so very close." Chad then sends another message to Zulema on July 13th, 2019 at 9:57 a.m. "Hi, Zulema. Yes, I would be happy to give you a blessing, possibly this evening or tomorrow. It's crazy about Charles, but such a relief."
So in looking at that second message from Chad Daybell, there's a reference to Lolo. Did you determine who Lolo was in your investigation?
I did.
And who is that?
Lolo is a nickname for Lori Vallow.
Was there anything else that stood out about that message in relation to your investigation?
On the message, the second message,
Yes, the second message.
that Chad was thanking Zulema for her help with this evil spirit that Charles was referred to.
And this message was sent just 9 days before Charles Vallow was killed?
Yes.
And then looking at the next message, is there anything that stood out to that one about you?
Other than the last sentence, it is crazy about Charles, but such a relief.
Had you looked through these phones and iCloud accounts, did you ever see any indication of grief over the loss of Charles by anyone?
I did not.
And then turning to this next slide, I think you've already talked about the KK Walker. Can you tell us what we're seeing here, though?
Yes. So this is a email that came that we recovered from the kkwalker75@yahoo.com address. And this particular email was sent from KK Walker to chad.daybell@gmail.com on April 21st, 2019 at 6:20 a.m. Yes, April 21st, 2019. So the email reads, "Dear Brother Daybell, hi, this is Karen from Avow. I contacted you a couple weeks ago to see if you would be willing to come speak to our youth here in Houston, Texas. You said you probably could if there was a way to cover your expenses. Since then, I can't shake the feeling that you need to come share your story, particularly about chasing paradise. We are near the Houston Temple, and this summer our stake is focusing on family history work. My reason for contacting you again is that we have a stake youth conference planned for all day on Saturday, April 27th. The focus is on the temple, and I know you would energize the kids with your stories. We expect about 400 kids to attend, including some parents. I know it is extremely short notice, but is there any chance you could come? A high councilman is currently the main speaker, but he said he would be happy to let you speak instead. My husband and I have been financially blessed and would pay for your flight. We also have a casita attached to our house where you could stay and not be bothered. Also, my daughter mentioned the young single adults would love to put together a fireside on Sunday evening. I realize your main goal is to sell books, and that wouldn't be possible at these events, but I know the interest in your novels would skyrocket here. I'm sorry it's so late. If possible, please let me know as early as possible in the morning so we can include it in the Sunday announcements. Also, we'd want to get your flights booked. If you're able to do both events, we could fly you in Friday, then depart on Monday. Please let me know if this is possible. We would love it. Karen Walker.
And again, who did you link that KK Walker Yahoo to?
So the KK Walker was linked to Lori Vallow. The information provided by Yahoo indicated that the IP address where this account was set up was in Katy, Texas, near where Lori was living at the time. The date of birth associated with the account was a variation of Lori's date of birth, but the phone number linked to the account was the same phone number that Lori would use.
And again, the date on this is April 21st of 2019. Was Charles Vallow still alive at that time?
Yes, he was.
And was Tammy Daybell still alive?
Yes.
Did Chad Daybell respond to this email?
Yes, he did.
And if we look at the next slide, can you tell us what we're seeing here?
This is a response to that email obtained through Yahoo. Hello, Karen. Yes, I will be able to come. So let the wards know. I can talk to you later about arranging the flight, Chad.
And through your investigation, did you learn whether or not Chad did travel to this event, or in response to this email, I should say?
I don't have independent knowledge of whether he did or not.
Did you in fact pass your findings along to other law enforcement?
Yes, I did.
And other law enforcement may have followed up on that?
Yes.
And Your Honor, this exhibit is ready for submission to the court.
All right.
Detective Duncan, do you recall being contacted about a call placed to a mortuary?
I do.
And do you recall who contacted you?
Yeah, it was Agent Ricky Wright with the FBI.
And did you end up following up on a call made to a mortuary?
I did.
Did you learn where that mortuary was located?
Yes.
And where was that?
It is the Valley of Sun Mortuary located in the southern portion of Chandler, Arizona.
And did you end up recovering a copy of a recording of the call?
Yes, I did.
And was it actually a two-part recording?
Yes.
And Your Honor, it's my understanding that these exhibits have already been stipulated to by the parties. They've been marked as states 44A and states 45A.
That's correct, Judge.
Okay. And to be clear, explain what they are again, Ms. Blake.
They are a recording of the calls just referenced by the detective.
Okay, so each one of those exhibits contains a digital file of a recording individual.
Yes, Your Honor.
Okay. 44A and 45A are admitted.
And Your Honor, I do have a copy of those for counsel as well.
Judge, I have copies. Thank you.
Okay,
And I would, now that those are admitted, I would ask to be able to publish those.
you may publish them.
If I may have just one moment, Your Honor.
Third ring answer.
Funeral home.
Hello, my name is Sarah. I'm assisting them with their calls. How can I help you today?
We just had a death in the family, and we really don't want anything but a cremation, and then to send the cremains to a family in Louisiana. Just a simple, nothing other than a cremation and sending him to his family for a service in Louisiana. So, is there any way to know a ballpark price on that?
Yes, and I'm sorry for your loss.
Thank you.
Okay, let me transfer you over to the director who can assist you with the pricing. What is your name, please?
It is Chad Daybell.
How do you spell the last name, please?
Daybal. Daybell.
How are you related to the person who passed?
I'm his nephew.
And then also, this is for the Valley of the Suns in Chandler, correct?
Yes.
Thank you.
Yes, he lives there in Chandler. I live in Iowa, so I'm just
Oh.
trying to help out.
Oh, okay, thank you. Yes, what is your uncle's name for reference, please?
He is John Daybell.
And last name?
Well,
Yeah.
Dabal.
Okay.
The same. John. Uh-huh.
Does he have a middle name?
Myron.
Myron?
Yeah.
And Chad, what is your phone number in case we get disconnected?
It's this number, 515. I don't actually know my own number. Let me look real quick.
Thank you.
Mhm. Five 402-0143.
Thank you. Is he at a nursing home, hospital, or residence?
He passed away in a hospital. I don't know the details. I'm just calling.
Yeah, it's just for to know, because sometimes it's different if it's a residential or hospital or a nursing home. Okay.
Thinking they're sending him to the medical examiner. I'm not sure. I should have had more information before I called. I'm sorry.
That's okay. All right. Cremation with shipping. To which which city?
New Orleans. Again.
Okay, one moment, please, Chad. Stay on the line. Let me
Okay.
transfer you over to the director who can assist you with that.
All right. Thank you.
Thank you. Hello, Chad.
Yeah.
Thank you for holding. I do have the director, Carissa, on the line to further assist you.
Okay. Thanks.
Thank you.
And Your Honor, that was State's Exhibit 44A.
Okay,
And I would now ask to publish State's Exhibit 45A.
you may.
So my name is Chris. I'm a funeral director with Sally System Mortuary and Cemetery. I understand that your uncle passed away.
Yes, and I'm just starting the process for the family. He didn't have many relatives. I'm his nephew. I live in Iowa. But what
So
they
sorry to
want
hear
to
that.
do is, it's, yeah, sad to see him go. Yeah, I think he's going to the medical examiner. I don't know all the details, but what the family basically wants is just to have him cremated there in Chandler and then have its remains shipped to New Orleans. And we'll
Okay.
deal with the service later. So just trying to get a ballpark price.
Okay, so for a cremation, we are able to do our cremation for $1,695. Now, what that's going to include is the transportation into our care, the transportation to and from our crematory, our basic
Mhm.
professional fees, as well as our crematory fee. Now, there's going to be a couple other charges there for you.
Okay.
So we are going to have death certificates, which are $20 a piece, plus a processing fee,
Okay.
$15 permit fee,
All right.
and then we're able to do that transfer through the mail for you, and that's $150 fee for you.
Okay. Like through UPS or something, I guess.
Okay,
So close, about 2,000 probably, kind of a ballpark, yeah.
close to, yeah.
Okay. Well, that helps me a lot. I'm going to call one or two others, but I'll get back to you if we come that direction. Thank you so much.
You're
Oh,
welcome. And if you need anything else, give me a call.
okay. Thank you.
All right, thank you. Bye-bye.
Bye.
Could I have a sidebar with council, please?
Yes.
All right, council, we had a sidebar just discussing scheduling here. We're going to go ahead and take the lunch break at this time. I am going to advise the jurors, you're going to have a slightly longer lunch break, maybe not slightly, probably more like an hour and a half than an hour based on some motions the court's going to hear outside of your presence during part of that break. So we'll probably have you returning for further evidence, hopefully around 1:30. And if we do that, I'll also inquire as to whether or not you think we could just go through 2 hours without an afternoon break, potentially if we start up around 1:30. So,
And I believe the state can do so as long as the jurors are good with it.
okay, I'll ask the jurors once you return back, so we kind of know what is left in the afternoon after that. So we will go ahead and take our lunch recess at this time. I'll have the jurors be excused and we'll argue a brief motion after they've been excused from the courtroom.
All right.
All right, thank you. Please be seated. For those in the courtroom in attendance, you're welcome to stay for a motion hearing. You're also welcome to leave for the lunch break if you'd prefer to do that. It's a motion that we're going to just hear an argument at this time, whether or not it will be open or closed hearing. So if anybody does want to leave for the lunch break, you're welcome to. Otherwise, we'll proceed under this rule 32. Awesome. Thank you. We'll have the witness step down and return too. Sorry, I lost track of you still sitting up there. All right, counsel, we've got a motion in limine that was filed on April 15th by the state. It was filed on shortened notice just yesterday. I haven't expected defense counsel to be able to have time to make any filing in response. However, I've allowed Mr. Pryor an opportunity to review the motion and would permit oral argument. That hearing we're going to take up later after our lunch break. The question right now is the state did file this with a request for an expedited hearing, which I'm granting and having that heard on the merits today. Also under a motion requesting that the motion in limine be sealed. The court is holding a hearing at this time to determine on the state's motion whether or not the hearing will be sealed or will it be open. And so that's governed by our Idaho Court Administrative Rules 32. If the state wants to present any argument as to a basis for sealing that hearing this afternoon, I'll hear that at this time, and then I'll hear a response from the defense. So who is going to be arguing as to the motion to seal?
I will be, Your Honor.
Go ahead, Ms. Blake. And so to be clear, not into the merits of the motion in limine, just on the issue of sealing. Correct.
The state did file a brief. I recognize this is short timing and defense counsel may not have had an opportunity to do the same. In the brief, I think both in the motion to seal and then reference to the brief without getting into any argument lays out what the state's concern is depending on any ruling on the motion is why the state had requested that this be filed under seal. Depending on the outcome could have an impact in the future, but we do recognize that there is a jury that has been seated at this point and the court may determine that that is no longer a concern. So we would simply defer to the court on this and just reference back to the motion as to the state's rationale for the original request.
All right, thank you, Ms. Blake. What's the defense response as to the issue of sealing or not sealing the upcoming hearing?
Judge, the state correctly pointed out that the jury's been sworn in. The evidence is has proceeded at this point. Without getting into too many factual issues, Judge, the information that's in question was listed as an exhibit and disclosed to the state on March 15th, I believe, originally in the list of exhibits and identified on that date. Then it was provided to them just before the start, a week, I think, before the start of the opening statements with the actual copy of that. So 3 weeks later now we're dealing with this. But just so everybody's clear, Judge, the information that I'm intending to use is going to be limited to impeachment. And as we all are aware, that if the information is used for impeachment, it's not necessarily admitted as evidence, but in all fairness to the state, it was provided as an exhibit. But the defense's intention is to use this solely for impeachment evidence.
All right.
So I would expect that this is nothing that needs to be sealed.
Okay, well, the court in this case has previously many times sealed certain issues relating to evidence, mostly under Idaho Court Administrative Rule 32, which is a long rule with a lot of subparts. Somewhere among in there is a paragraph E, which is kind of a catch-all that indicates that things can be sealed if it's necessary to temporarily seal or redact documents to preserve the right to a fair trial. And in this case, of course, we had quite an ordeal and undertaking to find jurors who were not prejudiced by pretrial publicity, and pretrial publicity all seemingly tilted one way in the case, where many hundreds of potential jurors were unable to serve in this case because they already had a opinion that the defendant was guilty. So avoiding that and trying to get a fair and impartial jury led to the court's orders many times before on that very issue. The issue now, where the companion case has already gone through trial and now we have a jury seated in this case and impaneled, my concern is alleviated as to picking jurors that are not predisposed to a opinion in the case based on pretrial publicity. And so without that concern going forward, the court will determine that the hearing does not need to be sealed. And so under Rule 34, the temporarily unsealed or temporarily sealed motion will be unsealed, as well as the hearing will be conducted in an open hearing today. When we argue that motion, counsel, I don't expect it will take too long to argue, but I indicated to the jurors they'd be back around 1:30 to start evidence again. So if we call the motion at about 5 or 10 after to give us a full hour for lunch and court preparations, is that timeframe going to work for the state?
That will work for the state, Your Honor. Thank you.
All right. And will you be arguing that, Ms. Blake?
Yes, Your Honor.
All right. All right, Ms. Pryor.
And I'll be arguing it for the defense, Judge.
I understand that. So for terms of timing, then let's try to get that on the record. Let's call it at 1:05. All right, we'll be in recess on the lunch break until then.
All right. District Court's again in session.
Thank you. Please be seated. All right, council, thanks for returning. We've got a motion scheduled being heard outside of the presence of the jury. We're on the record on KCR 22-21-1623. The state filed a motion in limine yesterday. Well, along with a request to temporarily seal, which based on a hearing earlier today is unsealed, as well as the hearing being held in public here. However, again, outside the presence of the jury. I also have granted the hearing to be held on an expedited basis based on the fact that we are in trial and the issue has arisen and developed during trial, which doesn't permit the typical response time we would have for a motion in a case. So based on that, I am going to allow for some argument on the motion in limine. I'll hear response from the defense after the state argues the motion. And after consideration of the arguments, I should be able to make a ruling this afternoon before the jurors return. So, Ms. Blake, I understand you'll be arguing on behalf of the state. Is that correct?
That is correct, Your Honor.
All right, if you'd like to present argument in support of your motion limine, I'll hear that at this time.
Thank you, Your Honor. And as this court is aware, we've already litigated a very similar issue in front of this court. However, this one deals with a different witness and some different materials. So during preparations in this trial and getting ready for witness prep with one of the witnesses in this case, specifically Melanie Gibb, the state had reviewed a discovery response that was provided by defense counsel. This was provided to us within the discovery timeline as required. This was my first time reviewing it in full. And this had previously been provided by the state, actually in the prior pending matters against both Chad Daybell and Lori Vallow. They were originally provided in cases CR 22-20-755 and CR 22-2838 on approximately March 3rd of 2021. So defense counsel would have received them in that case initially. Subsequent to that, I believe they were re-provided in this case's discovery on December 14th of 2022. Defense redisclosed them to the state on or about February 1st. As indicated, in preparations for the trial, I had not reviewed those in full until recently. Upon a review of those and then coupled with defense counsel's current state of cross and opening statement, looking at those, the state had concerns that we may be back to litigating in the future the issue of whether or not Prosecutor Wood is a witness. When I reference a previous hearing dealing with a similar issue, it dealt with that, wherein this court determined and quashed a subpoena that had been served on Prosecutor Wood. And while that was in relation to another witness, a review of these coupled with the arguments being made in the state of the cross-examination raised the state's concern that there could be another attempt by the defense to make Prosecutor Wood a witness, and specifically in relation to Ms. Gibb. The state disclosed in this motion the content of the communications that we feel the defense may be relying on or may use. We also have outlined an argument specifically starting with a determination as to whether or not the evidence is even relevant. This court had previously put in effect an order, and in the prior case numbers that were mentioned, the court had also mentioned the requirement for a taint hearing. Although those were in relation to other witnesses than Ms. Gibb, I think it would be a similar standard that should be required or would be required if it is the defense's intent at any point to attempt to call Prosecutor Wood as a witness. The reason the state brought this issue now is we don't want to get through the case in chief and have that become an issue if that's in fact where the defense is headed. We felt that it is an issue that should be determined sooner than later. We have suggested that if the court does have concerns that these could be reviewed in camera and/or a hearing could be conducted outside of the purview of the jury for this court to make a determination whether or not any prospective testimony would be relevant to this case and either to the state's case or to the defendant's case. In addition to that, we've outlined and gone through again, and I know the court saw essentially the same case law, the same argument in that previous case, but we did include that we do recognize a defense attorney can be allowed to call a prosecutor and a witness, but it is disfavored. Case law makes that clear, as well as that any attempt to do so should be decided in advance of trial. We've included the case law outlining that and essentially the test required or the high burden on a defendant to show that a prosecutor would need to be a witness, which is that compelling need test. We don't think that that's been met, and that would be the request if this court is inclined to allow these messages in and/or even allow an attempt to have Prosecutor Wood become a witness. We feel that that would be appropriate for the court to conduct a 403 analysis outside of the purview of the jury and/or a taint hearing if necessary. We would point out that from the state's review, it is very, very rare for courts to find that a prosecutor should be a witness. And in the cases the state found, it either involved the prosecutor being a witness to the actual facts, so a factual witness to the case, or where they are a witness to a statement that contradicts a later statement made by a victim or a witness, and they are the only available witness to that contradictory statement. So I don't think we're anywhere near that at this point, but the state did have concerns that's where we could be headed. In an attempt to avoid running into that issue down the road, we wanted to address this now. Further, I think it would also determining before Ms. Gibb takes the stand, kind of what the parameters are with regard to any allowance of those messages and/or any parameters surrounding them would be prudent to do outside of the purview of the jury rather than in front of them. So that is the secondary reason for this. Finally, the state would argue that the defendant cannot invite error. We recognize that we are already into the trial. Testimony has already been given. The jury has already heard from the prosecutors in this matter. But we do believe that if there is any attempt to call Prosecutor Wood as a witness, that at this point, any objection to that has been waived by the defense and/or would be invited error if we end up at that point. So we would also just note that for the record. But at the end of the day, we are asking the court to consider either excluding the messages and/or excluding Prosecutor Wood as a witness or any attempt to call him as a witness and/or if necessary, if the court has additional concerns that a taint hearing be conducted outside of the purview of the jury in order to determine whether or not we would get to that point of the defendant meeting that compelling need, which is a high burden. I think that's all the state has unless the court has any questions.
All right, the question I have, I understand your motion as it relates to wanting to exclude defense exhibits 113. Also on the issue of whether or not Mr. Wood could be called to be a witness and invited error doctrine that you've discussed. In your ruling, are you also seeking a specific court ruling as to prohibiting certain types of cross? I know the concern has been raised about the cross and whether or not trying to push into that territory. And in this motion, I guess I'm not entirely clear if you're seeking a ruling when you talk about parameters on disallowing some scope of cross, and if so, what you think the topics that would be disallowed would be.
Thank you, Your Honor. And I think I can try to clarify that. I guess where the state is asking that either the messages be prohibited and/or that prosecutor would be prohibited from being called as a witness or the defense be prohibited from attempting to do that. When I talk about the parameters, I guess what I'm suggesting, and maybe it would require an in-camera review by the court, but if this court does determine that Prosecutor Wood cannot be called as a witness, I think it would be parameters around the cross of a nature such as that. I guess the state's concern is if the defense is allowed just unfiltered cross completely, and this court has made rulings that they're not going to be allowed to call Prosecutor Wood as a witness, we may still end up in the same position of an attempt to confuse or mislead the jury, or to get into parameters, or to get into areas that this court has essentially indicated are off limits. So I guess when I reference parameters, depending on the court's ruling, if certain of those messages can't come in, then I would think that those wouldn't be something that we get into cross-examination. Similarly, if Prosecutor Wood's not to be called as a witness, I think the cross would need to be structured in such a way that it isn't suggesting or trying to set up that he would have to be a witness.
All right, well, I appreciate the additional explanation on that. Mr. Pryor, and I understand this was a hearing expedited, putting you in a tough spot in terms of the time you would have to respond. And I do have that in mind, so I haven't required you to submit any written response or expected it, quite frankly, knowing that we're in trial and this is a very short noticed hearing. However, I do want to give you an opportunity, knowing now that you have had an opportunity to review the state's motion and hear the argument. What is the response from the defense on this motion in limine?
And Judge, for the record, the state provided me their notice on Sunday night, I think at about 11 o'clock, which was a day and a half ago. I didn't get a chance to read it until after court. I was preoccupied the morning of yesterday's court with some other matters relating to this case as well, and eventually had to get to it late last night and took a look at it. This is my concern, is what the state is suggesting is that in some way they can dictate where I can go on cross-examination. They would like this court to enter an order saying, Mr. Pryor can only talk to certain witnesses about certain topics in a certain way, and they're trying to handcuff me from going into areas that they will find maybe a little sensitive to their case. That is extremely problematic. Okay, Judge, I'm going to cite Idaho Code 9-201. And 9-201, and I apologize, I don't have it memorized. My memory isn't as good as it used to be, so I'll have to read from this. But in pertinent part, Judge, it says, who may be witnesses, credibility of witnesses. And I'm not talking about who may be witnesses. I don't have any desire to put Mr. Wood on the stand. That's not what this is about.
And so I do want to be clear on that point. You've said that. I've previously ruled on that in the other cases. And you are representing the court here at this time. You are not intending to call Mr. Wood. Is that correct?
I'm not. And I'm going to follow, although I don't agree with the court's previous order as it related to the other phone conversations with Mr. Wood and the 4 or 5 other witnesses in which we ran into some issues about similar problems here. The court made its ruling and I'll follow the court's ruling. But what I am allowed to do is they provided me with some information in the Chad Daybell's original case. They provided it in Lori Daybell's as well. So they had possession of it. And quite frankly, what it comes down to are emails between Melanie Gibb and Mr. Wood. And Judge, for the record, I'll make it clear that we're not talking about a couple of emails. From May 6th of 2020 to 11/4 of 2020. Well, let me change this. In essence, Judge, over a period of time, we're talking of 6 month plus period of time, we're talking about 340 text messages that the two of them exchanged. 143 can be assigned to Mr. Wood. 100 and I believe 97 could be assigned to Miss Gibb. And these are text messages for pertinent part address issues relating to this case. Now, one of my concerns, Judge, is that the question I am allowed to ask is have you had any communication with anybody, prosecutors in this case? And I've done it on previous witnesses here. And what the state would like to do is stop me from inquiring why Mr. Wood has had 340 exchanges of text messages between him and Melanie Gibb over well, I want to be careful about what I say here, 5/6/2020 to 11/4/2020 were a portion of those, 7/13/20 to 8/3/20 a 2-week period, Judge, from 7/13 of 20 to 8/13 of 20, there were approximately 129 texts over that 2-week period. So this is the concern. And again, I'll go back to Idaho Code 9-201 and I'll read, this is the fourth line down. Therefore, neither parties nor any persons who have an interest in the event of a crime, nor persons on account of their opinions on matters of religious belief, although in every case the credibility of the witness may be drawn in question by the manner in which he testifies, by the character of his testimony, or by the evidence affecting his character for truth, honesty, integrity, or his motives, or by contradictory evidence, and the jury are the exclusive jurors of credibility. So what the state is trying to do is basically circumvent Idaho Code 9-201. What they'd like the court to do is they'd like the court to say, Judge, we're not going to let a jury hear what Mr. Wood and Ms. Gibb have been talking about for 340 text messages that are related to this case. And we're not going to allow the court to allow the witnesses to, or the jury to judge the credibility of what was said in those text messages. That's what they're trying to do. And Judge, that's in complete violation of 9-201. This isn't a balancing test. That's what the problem with their analysis, judges. They'd love to put you into a taint hearing. The difficulty with a taint hearing, Judge, is this. 404B, the rules of evidence, 404B, and we touched on this yesterday, Judge. They'd like you to do the relevance of 403 balancing. They'd like you to do 404B and do that. The problem is with 404B, Judge, at the bottom of 404B, you talked about it the other day. It applies to prosecuting attorneys who are trying to bring in prior bad acts. That has nothing to do with this, and this balancing act has nothing to do with this. The reality is this. Does this information go to the credibility of a witness testifying in the case? And what I would suggest to the court is simply this, is that when a prosecuting attorney engages in discussions with a witness to the tune of over a 7 or 8 month period, 340 texts, and I've included them, Judge, I believe it's 113 is my exhibit that I provided.
I do want to clarify. So 113 is not a summary, but it includes all of these texts you've referenced.
Right.
Okay. I
And what
just wanted to be clear
113,
what-
Judge, is it's a specific response to discovery that was provided upon seeking some information from the state. And it's I believe it's A through K, if I remember. And Judge, this was disclosed by the state 2 or 3 years ago. On the 15th of March of this month, I provided them a list of the exhibits that I was going to provide. And Judge, a week before the trial started, I took the liberty of providing them. I wasn't afforded the same courtesy, but a week before the trial even started, Judge, I handed the state a copy of all my exhibits. That was over 3 weeks ago. So they've had ample time. Last time I've checked, my count is there's 1 defense attorney and there's 4 prosecuting attorneys. And they should have had ample time to go through my exhibits, and suddenly this last minute quarterbacking of saying, this is a way we're going to stop Mr. Pryor from talking about evidence when we call Miss Gibb. And I don't appreciate the tactic. I don't appreciate what they're doing here, but the reality is they're not allowed to do it. And under 9-201, they don't have the authority to stop me from questioning a witness about communications with either a police officer or a prosecutor and try to show credibility, bias, or motive. And it's not an analysis of what you're looking at in terms of the content of those messages. And there's no authority that I'm aware of other than 90201 that gives them the right to dictate how I engage in cross-examination. Finally, Judge, I've made a representation to the court and I'm standing by that representation. I do not intend on calling Mr. Wood. What I do intend on doing is have, when Miss Gibb's up there, and either on my direct examination when she's called back, or on my cross-examination, I'm going to call Miss Gibb and I'm going to question her about what kind of contact she's had with Mr. Wood over a certain period of time and the nature of those discussions. And I have copies of all the emails and I can question her. If she remembers the conversation and is able to discuss it, there's no need for me to publish it. But if she can't remember it, Judge, I have every right to refresh her recollection with copies of those emails. And I have every legal right to do that. And if that means that I show her copies of those emails to refresh her recollection, I can do that. That doesn't mean I need to call Mr. Wood. All I'm asking her to do is to recall a discussion she had with him about the case and the subject of those emails or excuse me, I keep saying that, text messages between him and Miss Gibb. And that's totally permissible. There is no limitation, nor is there any definition on what I can use to refresh a witness's recollection. I have free rein to use any information I feel fit to put it in front of a witness and say, will this help you refresh your recollection about testimony? And that's exactly what I intend to do.
All right. I will note, Mr. Pryor, on the issue of whether or not you intend to call Mr. Wood, we just before trial had a hearing where the court quashed a subpoena that was served on Mr. Wood. So I certainly understand the state's concern about a tactic, if it is, from the defense to call a prosecutor in the case. We've been through that since these previous cases, the 2755 and 838 cases dealt with that extensively in written rulings. It's been going on for several years now, the same issue, and the courts ruled multiple times going through that analysis. And again, cited in the state's brief about, and I do agree with the way the state has framed the issue, looking at the State versus Aguilar case, 135 Idaho 894, that it is very disfavored for a prosecutor to be called. And in those rare circumstances where they are an actual observing fact witness, or perhaps the only other witness that could corroborate some testimony or something. Besides that, they have to show, in order for a prosecutor to be called, that the testimony would be vital to the case and the inability to present the same facts from another source. So again, with the subpoena being served just before trial, I'm not surprised the state still has that concern. And I will indicate, without additional need for argument from the state on the invited error doctrine, I would agree with that as well, that if that were a strategy here to not have the issue come to the forefront before trial started, and then attempt to do that unless it somehow met that very narrow structure that is laid out in the case law, I don't see that happening here. However, I do want to hear some additional argument back from the state on the issue of the Exhibit 113, the communications, and whether or not Mr. Pryor should appropriately be allowed to use that as a way to question the credibility of the witness or potentially impeach if there's contradictions in what the witness may say versus what could be contained in 113.
Thank you, Your Honor. And I guess to be clear, the state is not in any way trying to stop the defendant from being able, or the defense from being able to conduct appropriate cross-examination. I guess I disagree a little bit. I think the court does have the ultimate discretion over the allowance of cross-examination in compliance with the rules of evidence to make sure people stay within the bounds. What the state has concerns about was any attempt by defense to misconstrue the content or attempt to create a situation where the defense then argues, well, we have to put Prosecutor Wood on the stand, and especially without conducting any kind of a hearing in advance. The state does appreciate the comments made by the defense that there is no intent to call Mr. Wood as a witness. I guess it still makes the state a little bit nervous because, as the courts pointed out, we've litigated this issue multiple times. The state also recognizes that sometimes trial strategies change. And if at any point that does, the state still doesn't want to end up in that position. Because I guess while defense says we're just going to question her and maybe show her the messages, it still creates a concern for the state that then later the defense is going to say, given her answers, given something, we now think we have to call Prosecutor Wood. So while I appreciate the representations made by defense counsel, I think that is still the concern surrounding these messages. The state does not disagree that so long as the defense counsel sets the proper foundation, he would be able to absolutely use these messages if he were trying to introduce them. I guess I should be clear on the proper foundation. I don't disagree. I don't think the state disagrees at all that cross-examination can include asking about meeting with the state, meeting with investigators. That would all be fair game. The concern would be an attempt to misconstrue the statements. And that was why the state was asking the court to potentially review them in camera to make any ruling regarding those messages or conduct a taint hearing if necessary. I think the court was very clear with defense counsel that if there was going to be an attempt to call Prosecutor Wood, a taint hearing would be required. I guess the state is not still completely assured that this would not still result in that attempt to essentially circumvent the court's prior orders. So
I'd like
that's
to
the concern
respond.
with the state.
Okay, thank you, Ms. Blake. Mr. Pryor, Ms. Blake was still talking, so I'm sure that
Okay.
didn't come on the record. What did you say?
If I could respond briefly, Judge.
You may.
Thank you, Your Honor. Judge, I've already assured the court, and I'm not going to violate the court's order about Mr. Wood. And frankly, the state can say if certain things happen, but the reality is this court can make rulings on relevance issues as it relates to certain things. But when we're talking about credibility, Idaho Code 9201 allows me the leeway to go forward and impeach a witness or ask a witness about communications with a prosecuting attorney. And it's perfectly permissible. Just because Ms. Gibb may say something different than what a text message is, I can show her, refresh her recollection, and that's as far as it goes. And I understand that. I understand the limitation that's put on impeachment and refreshing someone's recollection. It doesn't open the door, and the state's using this opportunity to say, well, Judge, in the past, you've stopped Mr. Pryor from having him talk about his many conversations with the other witnesses. But in this situation, it's a different story. Ms. Gibb is the witness in this case. Her testimony is crucial to the state even trying to prove their case. And the reality is that I'm allowed to talk about communications with Mr. Wood and Miss Wood Mr. Wood and Miss Gibb to the tune of 340 text messages over a little more than a 6-month period. So I am allowed to go into that, and I'm going to go into content if that content. So the suggestion is that there should be a taint hearing. They are completely off base. And what they're trying to do is they're trying to, strap a motion that has previously been ruled on and say, Judge, oh, there still may be some threat here. We really better go through this long process and have you evaluate things. And I'm going to object if that's where we're going. I'm allowed to go into the credibility, bias, and motives behind any witness. And I'm allowed to question them about anything that may go to bias, motive, and in that regard. So I appreciate the state conceding finally that I can use this information on cross-examination, and Judge, as a representation on cross-examination and maybe direct examination when Ms. Gibb is subpoenaed, that's where I intend to go. And again, I will reiterate, I do not intend to call Mr. Wood, nor do I plan some scheme. Sounds a little paranoid to me, but that's fine. But again, I'm going to follow this court's order. But 9201 allows me to go into the credibility of the witnesses, and I don't feel like I need permission to do that.
All right, the matter's been argued. I am ready to make a ruling on it. So I am going to put the ruling on the record. I'll just have an order entered that will say for the reasons stated, because I don't expect either side to draft out in an express order the analysis I'll go through here. So as it relates, first of all, I'll indicate that 9201, of course, reiterates the provenance of the jury, that they're the ones that determine credibility of witnesses ultimately, and that clearly states that. The matter of evidentiary ruling and relevance is always, though, for the court to determine what evidence comes in or what does not come in based on objections or proffers during the trial. And the court always has to consider Idaho Rule of Evidence 401, which is whether or not evidence is relevant, and 403, which is potentially, even though there is some relevance, evidence can be excluded if the evidence is unfairly prejudicial more than probative. And so the court determines that, and that doesn't run afoul of 9201, as the defense has argued in any way, or the two are mutually compatible in that it's the court that will determine relevance based on 401 and 403. And then the jury's left to determine ultimately if a witness is credible or not. So in this issue here with Exhibit 113, I will indicate that much like the parties here, the court's busy as well during trial. I have not gone through Exhibit 113, and nor I don't know if I want to or care to read the hundreds and hundreds of text messages that are apparently, or other messages that are contained in the exhibit. Without knowing precisely what's in all of those, I can't make a ruling to just wholesale exclude Exhibit 113 as the motion in limine would seek and state that that's an irrelevant exhibit. Parts of it may be, parts of it may not be. The whole thing may not be relevant. The whole thing may be relevant. I just can't say at this point until the witness, Ms. Gibb, testifies. I would state that to the extent anything comes up within those messages that may well be proper on cross-examination as impeachment if the witness begins contradicting things that were previously said to the prosecutor or vice versa, or on other factual allegations that may come up during cross or direct. So the court's going to deny the motion as it relates to a motion to in limine to just exclude Exhibit 113. Just have to see how the trial develops with the testimony of that witness. However, I will state that I'll be watching very carefully as to whether or not there really is any relevance to the testimony of Ms. Gibb, because attorneys are entitled to talk to witnesses, help them get ready for trial, not to change their testimony or not tell the truth. However, if it's just simply matters of, what time should I be there, that kind of thing, if it's not relevant, then I'm going to watch. And if an objection comes up about relevance on any of these prior communications, despite 9201, I can simply determine if I think it's appropriate that the jurors shouldn't be hearing about these communications if it does nothing to help them assess the credibility of the witness. So ultimately, it has to be an assessment of the witness's credibility. Quite frankly, I don't think a taint hearing is necessary or required at this point. If during the course of that testimony, we start going right into this and it looks like there may well be an issue if that were to come up with credibility relating to Exhibit 113, I do agree that that should be done either in camera or at least outside of the presence of the jurors to avoid any unnecessary confusion the jurors may have sorting out what that would mean if it doesn't go directly to the credibility of that testimony. As it relates to Mr. Wood potentially being called as a witness, there's been a representation to the court today. That's not what the defense intends to do. This court's previously ruled that that was not going to happen. I still don't intend to have that happen. I can't say that could never happen because anything is possible. Particularly, it seems in this case. I'm not going to predict what may or may not come out, but I don't see much of a path forward given how strict the analysis is to permit that. So absent some really surprising or extenuating development, Mr. Wood's not going to be called as a witness and would not be permitted to under the controlling law. And finally, on that invited error doctrine, again, as I mentioned, to the extent this would be some sort of invited error, I would watch for any objection to stave that off if we started getting into an issue that could potentially bring a motion for a mistrial. So the ruling at this time then is on those matters, Mr. Wood's not going to be called as a witness. The Exhibit 113 is not excluded, but the court will watch for any relevance objections if the state believes it's not relevant. And that's the ruling on the motion.
Thank you, Judge.
All right, Ms. Blake, do you have any questions on that ruling?
I do not, Your Honor. Thank you.
All right. And counsel, one final thing, as I mentioned, if it becomes necessary for either an in-camera review or just argument outside the presence of the jury, please try and flag that, or I will sua sponte before a bell gets rung in front of the jurors they shouldn't be hearing. So that will conclude then the ruling on the motion. At this time, if we are ready, we'll have the jurors brought back in to continue testimony.
Yes, sir.
All right, thank you, Mr. Bailiff. Please be seated. All right, we are on the record on case CR 22-21-1623. The jury has returned, is all properly seated. Thank you for your patience while we went through a couple of matters outside your presence today. It would be the intent of the court then to go straight through till our time to end today at 3:30. Everybody on the jury okay with that plan? Okay, if anybody for whatever reason does need some break, just notify the bailiff. Otherwise, we'll intend to go through the afternoon. Ms. Blake, I believe you're still on direct examination with Detective Duncan, is that correct?
Yes, Your Honor, that is correct.
All right, if you'd like to recall the witness, then we'll have them brought in.
The state would call Detective Duncan.
All right, Detective Duncan has returned to the stand. Let me just inquire. I'm not singling you out, by the way. I do this with every witness when I remember, but over this break, did you discuss your testimony with anyone else or anybody else's testimony? Okay, thank you for confirming that. Ms. Blake, if you'd like to inquire, I'll remind the witness you're still under oath and you may question.
Thank you. Detective Duncan, before the break, we had just heard 2 calls that were linked to the same mortuary call. Do you recall those?
I do, yes.
And you recovered those as part of the investigation?
Yes,
And I believe you indicated the FBI had actually requested you collect those calls.
correct.
And prior to today, had you heard those?
I have, yes.
Have you heard Chad Daybell's voice?
I have.
Were you able to recognize the voice on that call?
Yes, I was.
And who was that?
Chad Daybell.
And during the call, did you hear him use any other name than Chad Daybell?
I heard him use a different spelling of the last name, yes.
And in that call, do you recall him saying where he was hoping to send the remains to once they were cremated?
I do.
And where was that?
Louisiana,
Do you know where Charles Vallow's place of birth was?
Louisiana.
Do you know if he still had family living there?
Yes, he did.
Did you also hear Chad give a location for himself where he was currently located in that call?
He indicated that he was in Iowa.
Through your investigation, did you ever find anything indicating Chad was in Iowa?
Did not.
And we've talked about that in your investigation, you looked at the iCloud accounts for Lori.
Yes,
Do you recall locating a copy of a patriarchal blessing?
there is an audio recording of a patriarchal blessing on Lori's iCloud account.
Did you listen to that blessing at some point?
I did.
And do you know who was giving the blessing?
Chad Daybell,
Do you know who he was giving the blessing to?
Alex Cox.
Are you familiar with what faith the patriarchal blessings are attached to?
I am
And what faith is that?
with the Church of Jesus Christ of Latter-day Saints.
And are you familiar with whether or not Chad Daybell within the church would have been authorized to give an actual patriarchal blessing?
Sustained. And Mr. Pryor, your microphone next time, please.
Detective, as part of the investigation, did the LDS faith come up?
Yes,
Did you review some things in relation to that faith?
I did.
And do you have some basic knowledge regarding the LDS church?
Yes, I do.
Do you know what a patriarchal blessing is?
I do.
Do you know who's authorized to give those within the LDS faith?
The stake president is authorized to give those.
Do you know what if Chad held the calling of a stake president at the time the blessing was given?
My understanding, he did not.
So he would not have been authorized within the LDS faith to give that blessing.
Correct. I think it actually, would correct myself, like it's a stake patriarch that gives that blessing, not president, but a patriarch.
So it's a specific calling someone has within the LDS faith to be able to give those blessings to another person.
Yes, it is.
And Chad did not hold that calling.
My understanding, he did not.
And Your Honor, the iCloud accounts have been admitted into evidence. The state has what's been marked as State's Exhibit 50, which is the referenced recording, where those iCloud accounts are already in evidence by stipulation. The state would move for the admission of State's Exhibit 50.
No objection, Judge.
Okay, Exhibit 50 is entered, and counsel, again, to be clear with those accounts, et cetera, as each individual item comes into evidence, as you just did, Ms. Blake, continue to please reference those specifically so the record remains clear.
Thank you, Your Honor. The state would ask for permission to publish State's Exhibit 50.
You may publish.
Chad Daybell, it is November 24th, 2019, a Sunday afternoon, 5:15 p.m. We're going to give Alex Lamar Cox a patriarchal blessing.
Alexander Lamar.
Alexander Lamar Cox. On this special day, I lay my hands upon your head to give you a patriarchal blessing as part of the member of the Church of the Firstborn that you have earned the privilege to be a member of. I do so by the power of the Melchizedek priesthood which I hold, and in the name of Jesus Christ, our Savior, who has authorized this blessing. It is grateful that you're receiving it as you move forward in your life. You are a member of the House of Israel, of the 12 tribes, and you are a descendant of Joseph through the tribe of Ephraim, which grants you many blessings. particularly of spreading the gospel in these latter days and protecting and preserving those who seek to learn the truth. And that has been your mission on this earth, and it will now expand into ways that we will discuss further in the blessing. I want to begin by opening up the portals of time and going back to your previous creations in which you've lived. I see you on the third creation as a valiant warrior fighting for truth and righteousness, always seeking to do what is right. Then you progressed and were selected by the Savior himself to be part of the fourth creation. Great warriors were needed in that creation. Powerful goddesses were needed to be protected, and you were selected to help protect your sister. And you helped her in numerous probations as a defender. You have a special bond even from the premortal world. You connected there. And as she grew in power, you were right there beside her, always. With a humble heart. You both always were so humble. So as this fifth creation began, after you had been exalted in the fourth creation, when you could have gone on to exaltation with Holly, resurrected being, you accepted the Savior's invitation one more time to come to this mortal realm, to condescend as a God. You help us. You have already assisted us in ways that can never be repaid. But you will continue to do so as you move forward in this life. You were born into a family that needed you desperately, with a set of parents who spoke of the gospel with their mouths, yet did not live it. And once again, you were reunited with a sister who needed you to survive such an environment. In no way was it a reflection on either one of you that you lived in that home. You were put there to help each other persevere. But the lessons you had to learn in your youth have now made you both strong, powerful servants of the Lord that would not have occurred in a traditional LDS home. You had to go to great depths to achieve tremendous heights. And the fruits of those trials are beginning to be demonstrated. You were granted to be a member of the Church of Jesus Christ of Latter-day Saints, and that was a strength to you. You learned about your Savior and grew closer to him and rekindled in some ways the connections you've always had with him. And through adulthood, you have refined yourself. And I just want you to know that at this time, the Savior is saying unto me, well done. Thy soul is cleansed. All is well. And now you'll begin into your terrestrial phase of this existence, that you'll be a powerful servant. I bless you with that knowledge that you'll now move forward as a true warrior in ways that can be demonstrated through not only physical action, but through spiritual power that is coming to you and will be bestowed upon you. I bless you with the knowledge that through marriage, you'll be united with a partner who will match your powers and complement your strengths. You'll be known throughout the world for your good-heartedness, your willingness to save souls all over the world through portals, and you will begin to gather the souls that come unto Christ. I see you in New Jerusalem, but more importantly, I see you as a messenger of the Lord. Surrounding New Jerusalem will be many small communities where people will come who aren't quite ready to enter those heavenly gates, those terrestrial gates. And one of your missions will be to go among the people and testify as a prophet that they can make it. You'll share your own experiences of overcoming adversity. And through your example, they will rise up. You will give tremendous blessings to them, raise their vibrations, and be like a brother to many of these fathers who may have had doubts, but through your strength, they will look to you as a hero, and you'll bring entire families that have been sanctified to the gates of New Jerusalem, and they will be allowed in on your word. Will be just one of the many wonderful experiences you'll have. I see you doing that often, but then based on assignments, you might go further into the world. Always serving, always a missionary. And with your companion, you'll communicate with Mother Earth herself. You'll know where to be before natural disasters happen, that you can be on location to protect key leaders, church leaders, and to preserve who should survive. Little children, I see you gathering up little children in your arms, saving them from floodwaters. Just having a collage of moments that await you in this life, rescuing the pure and innocent, leading them to safety. Dozens of instances. And you will be looked upon as an angel on earth. You'll literally glow for those who are allowed to see you. And those mortals who aren't allowed to see that will know through the spirit of the great power you possess. Proper time, after many years of service in such ways, as the second coming approaches, you will know when it's time to move to the other side. This body that has served you well will lay down one day, and you'll pass. Your spirit will leave this body, and you'll be greeted wholeheartedly and welcomed by the Savior himself. You already know him. But that reunion will take place on a greater plane. That the spirit, you'll feel at that time, the vibration will exceed all. Before the second coming even occurs, the Savior will let that body rest a day or two, and much like himself, you will be raised and be resurrected, so that when the Savior does return, you will be right at the front of that amazing team of angels. It will sweep the earth, much like described in the renewed earth. You will be there. It will bring you great joy to help Mother Earth transfer to a terrestrial realm, to burn away the celestial refuse. At that time, you and Holly will still have assignments here temporarily, but then you will move forward. She's already preparing a world for you two, and you will be able to be an eternal family with eternal children on that earth. And the glory will just continue for you out, on and on through eternity. So I bless you at this time with strength, power, and dominion over the callings you will receive, and that are moving towards translation and transfiguration, and that the Lord will be with you at all times. You will be a patriarch in your own home. You will give blessings similar to this. Your veil will be essentially gone. You'll be able to see into the past and into the future for these individuals and share with them the same type of knowledge and truth. I bless you with protection throughout your mortal life, that angels will now be assigned to you as you've reached this vibration. You have 9 angels assigned to you now to watch you from all sides through your faithfulness. I know you will stay faithful. You have a great mission. I protect you. I bless you with a strong protection against Satan and his followers, Lucifer, Cain, anyone else who seeks to oppose you. You will feel a new vitality and strength against them, and to use your priesthood to defend against them. I close this patriarchal blessing by assuring you that you will rise to an eternal glory, and that you will have an eternal family, and that your exaltation is assured through your faithfulness. In the name of Jesus Christ, amen.
Amen.
And Your Honor, I have States Exhibit 50 ready to submit.
Very well.
Detective Duncan, when you listened to that, could you hear a female also?
Yes.
Do you know who that female was?
Judge, I'm going to object without some proper foundation.
Sustain.
Based on your investigation, did you ever hear the voices of any other individuals involved in this case?
Yes, I did.
Did you ever hear the voice of Lori Vallow?
Yes, I did.
Do you know, based on that, did you recognize the female voice within that blessing?
I believe that voice to be Lori Vallow.
In that blessing, were there certain things that stood out to you?
There was a lot. First off, the date, November 24th, that is spoken, 2019 by Chad. And the other thing that stood out was at the beginning when he mentions that Alex is part of the Church of the Firstborn. That stood out to me. And then third, is in there talking about how he had already helped us more than they could repay him.
And breaking that down a little bit, with regard to the Church of the Firstborn, is that affiliated with the LDS faith to the best of your knowledge?
Judge, I'm going to object unless there's some foundation.
Sustain.
And Your Honor, if I may respond,
Go ahead.
I'm happy to lay more foundation, but I think I've already asked this officer previously on a similar objection if he looked into the LDS faith and is familiar with some of the terms used. So I think we have laid foundation for purposes of the investigation.
Judge, that's a pretty broad statement.
Well, if you'll re-ask the question, I thought you were talking about a different church. So go ahead.
Through the investigation, and are you familiar with whether or not the Church of the Firstborn is affiliated with the LDS Church?
It's my understanding that the two are not affiliated.
Is that why it caught your attention?
Yes.
Then you talked about a statement in there that the statement was made already assisted us in ways that can never be repaid.
Correct.
And again, Chad was giving the blessing,
Correct.
and it's your belief Lori was also present for the blessing.
Yes.
And then circling back, you said one of the other things that stood out to you was the date, November 24th of 2019.
Yes.
Do you know if Alex Cox is still alive?
Alex Cox is still alive during that time. Yes.
And do you know when he passed away?
December of 2019.
So just shortly after this.
Yes.
In the blessing, did you also hear reference made, you will know when it's time to move to the other side?
I did.
And that's Chad telling that to Alex.
Correct.
On November 24th of 2019, were Tylee and JJ missing?
Yes, they were.
And on November 24th of 2019, was Charles Vallow dead?
Yes.
And on November 24th of 2019, was Tammy Daybell dead?
Yes.
I have no further questions, Your Honor.
All right. Thank you, Ms. Blake.
And it is right.
Mr. Pryor, if you'd like.
Thank you, Judge.
Cross-examination. Back on. Thank you.
Okay. Done that twice. Not on purpose. May I refer to you as officer? Is that okay?
Absolutely. Yes.
Okay, thank you, officer. So you made mention of the fact that you familiarized yourself with the LDS faith. Is that right?
I was born and raised in the LDS faith. Yes.
Okay, so maybe you can enlighten me because this has been a learning experience for me.
It has me as well.
Okay, but you're obviously have a hand up. Is that you were at least part of that faith for a while? I don't have that. So you're familiar with the term doctrine of covenants.
Yes.
Okay, and in the doctrine of covenants, it talks about the Church of the Firstborn as part of the LDS faith. You remember that?
Well, I can't speak to the doctrine of covenants. I know what the
Okay.
doctrine of covenants are, but I'm
Well, you spoke to the doctrine of covenants, though.
that I know what they are. Yes.
Well,
But I don't understand
All
the
right,
content.
We're already having an issue with you talking at the same time as Mr. Pryor and vice versa. So please question and answer and don't talk over each other.
And Your Honor, I'm going to object as beyond the scope.
Overruled at this point.
Ms. Blake talked to you about the Church of the First, and you said that it wasn't part of the LDS faith. Is that right?
My understanding that the two were separate is what I said.
Okay, but the Doctrine of the Covenants talks about the Church of the Firstborn as part of the LDS faith. So where did you get your information from?
Basically, I had talked to other investigators that were part of the LDS Church, and we had heard through this investigation earlier the mention of the Church of the Firstborn,
Okay.
not understanding what.
So you really don't know whether it's part of the LDS faith or not, the Doctrine of Covenants, even though the Doctrine of Covenants discusses Church of the Firstborn being part of it, right?
Yeah, so like I said,
Okay.
other than, I don't, based on my knowledge, yes.
Now, and I'm going to go off topic a little bit,
Sure.
but some of the other stuff that I saw, Zaluma Pastena is talking about light and dark.
Correct.
And light and dark is part of the LDS faith too, right?
I have no idea.
Okay. Well, you said you familiarized yourself with it. Did you familiarize yourself with light and dark?
Not totally, no.
What about death and death percentages and things like that? Is that part of the LDS faith?
I've never heard of that.
Okay, but you don't know whether it is or not, right?
Correct.
Okay. And then we heard about some vibrations. I heard the word vibrations a couple of times. Are you familiar with that term within the LDS faith about vibrations?
I am not.
What about being possessed by spirits and praying for their removal from your body? Have you heard about that?
I have not.
Okay. But you don't know whether any of these theories are part of the LDS faith, right?
Correct.
Okay. Are you aware that in the LDS faith, that if someone is possessed, that if you pray for them, you can have them removed from their body? Are you aware of that?
I am not.
Okay. Now, we talked a little bit about the frequency with which on a specific day where Lori Vallow texted Chad Daybell 3 times in the morning, right?
Yes,
And that was with Charles Vallow, right?
that was the day that Charles
Okay.
died, yes.
And you made a point of bringing that up, that there were 3 messages that day in the morning, or at least there appeared to be some communication. We really don't know what they said though, right?
That's correct.
Okay. Now, when you go over the phone records, 3 calls in a day was not uncommon for them when I looked at the records, was it?
No.
In fact, it was frequently more than that in the morning, more than that in the evening, and more than that in the afternoon, right?
Correct.
So when you pointed out the 3, I got the impression what you were trying to suggest, that because Chad texted her or communicated with her 3 times, that somehow links him to Charles Vallow's murder. That's not what you're suggesting, is it?
No, I didn't suggest that. I made comment that that those show up in her CDR records, but they do not show up, those contacts do not show up in her iCloud records.
Okay, so just because there were differences, but it wasn't unusual for them to communicate several times a day at various times of the day.
Correct.
Right. After all, they were having a relationship with each other, weren't they?
My understanding, yes.
Okay. Now, Maricopa County, is that the county that you're in down there?
Yes, sir.
Okay. Do you know the prosecutor down there?
I know many prosecutors
Okay.
there, but are you referring to? a
Alistair
specific-
Adele?
Hold on, Mr. Pryor, he wasn't done answering.
Oh, I'm sorry. I thought he was, Judge.
Go ahead.
I do know Alistair Adele, the prosecutor, but I don't know her personally, but I know who
Okay.
she is.
So, you talked in great detail about the Charles Vallow case, right?
Correct.
Okay. And you're aware that Mr. Daybell is not criminally accused in the Charles Vallow case, right?
Correct.
You're also aware that in June 29th of 2021, the prosecuting attorney issued a statement in regards to his intent regarding Chad Daybell and the Charles Vallow case, right?
Yes.
Okay, and that was published on it was actually put on the web, wasn't it?
I'm not sure where it was, but
Okay.
I know we received something as part of our case file.
Right, and you're aware of what this prosecutor, after reviewing all of the information, made a determination, right?
Correct.
Your Honor, I'm going to object. The defense counsel's clearly headed into hearsay.
Well, it's already asked and answered without a timely objection, so overruled.
So did you happen to review what the prosecuting attorney's ruling was in regards to Chad Daybell and the death of Charles Vallow?
I am not privy to the ruling or the,
Okay.
basically the discussion of why a decision is made, other than
Okay.
the decision has been made.
But
not to-
obviously, and I'm doing it again, and I'll slow down, Judge, I'm sorry. A lot in my head, and I'm trying to get it out to talk to you. That's because there's different functions. Your function is to investigate a situation, correct?
Yes,
Gather evidence,
yes,
make a determination through the interview of witnesses.
correct.
And then at the conclusion of your investigation, you're to submit that information to a prosecuting attorney.
Yes,
The prosecuting attorney is not to get involved typically in helping you interview witnesses, right?
I don't agree 100% with that, because on all of our homicides, we do have an attorney that responds to our scenes and
Okay.
is aware of the circumstances surrounding it, because that attorney would have to speak at a hearing later on.
Okay.
So they need to know about the case.
Would they be participating in the interview of the witnesses?
No,
That's unusual, isn't it?
yes,
Okay. Okay. And it's unusual to encourage or tell witnesses what they should say and not say. Would that be fair as well?
for the attorney to tell witnesses?
Yeah, how to testify, what to testify to?
Yeah.
That's unusual as well, isn't it?
Well, there is witness prep in cases, so you can actually talk about, certain things, but no, I don't say it's not highly unusual.
Okay. So when we're talking about witness prep, that's a completely different thing than a prosecutor or an attorney getting involved in the actual investigation of a criminal matter, correct?
I can speak for Maricopa County. in
Okay.
mind that they would be present during the investigation, and they might have a suggestion or two, but they would stay out of it.
Right, okay. So is there anything that would refresh your recollection in terms of what the prosecuting attorney's ruling was on June 29th of 2021 regarding Chad Daybell?
There is what's called a disposition sheet on my report that would show that, yes.
And Judge, could I approach, you don't remember exactly the wording the prosecutor used, do you?
I don't remember the exact verbiage, no.
Okay, Judge, could I,
Roger. I'm going to object to hearsay here. The answer is going to call for hearsay.
Right. I'd like to, in camera, just on a sidebar, review the exhibit proposed. All right, Mr. Pryor, you can continue.
now, officer, as part of a disposition and a determination by a prosecuting attorney, and this is after the police officers have done their investigation, and the case is then put together and submitted to a prosecuting attorney. Are you following me?
Yes,
Okay, at that point, a prosecuting attorney makes a determination after they review all the evidence independently and make a determination as to whether or not they're going to proceed with charges against a particular defendant. Would that be fair?
that's fair.
And then in Maricopa County, how is that accomplished?
So we submit our charges to Maricopa County the courts, and then they review the case, and then they send us back their decision. So it's, like I said, it's been in the form of a disposition form. If they're not going to charge, they would send us a disposition form. If they are going to charge, then we would attend a grand jury or go through the process or preliminary
Okay.
hearing, whatever it may be.
And is that disposition form public record?
I believe so.
Okay. And do you recall whether or not the disposition record that was filed in regards to Mr. Daybell and his, you know, even any potential involvement with Charles Vallow, was that public record?
If it is in the report, then that would be public record, yes.
Okay. And is that published anywhere that you're aware of?
What do you mean? Is it published?
Is it published on the internet? Is it published on any sort of media?
No, the report wouldn't be published. You'd have to request that report.
Okay. Okay. So in addition, there would also be a reason for, or an explanation for why they didn't prosecute. Is that correct?
Like I said, I wouldn't know that information other than I would just get the disposition. I wouldn't understand their rationale for charging or not charging.
Okay, but they would give you some explanation in the reason on the disposition sheet, right?
Yes,
Okay. And did you receive a copy of the disposition determination by the prosecutor in regards to Chad Daybell in any potential involvement with Charles Vallow?
yes, I did.
Did you review that?
I did, and I scanned it to the report.
Okay, and do you have an independent recollection of what the reason was that they didn't charge Chad Daybell in the Charles Vallow matter?
I do not.
Okay, is there something that could refresh your recollection?
Sure.
Would the disposition sheet refresh your recollection?
Yes.
Judge, may I approach this witness?
You may. Well, let's have the bailiff carry that over.
Approach this witness. And let me know when you're done reviewing.
Okay.
Are you done?
Yes.
Was there a reason stated in this document as to why they would not prosecute Chad Daybell in the Charles Vallow case?
Yes.
Can you tell me what that reason is?
The reason they provided was no reasonable likelihood of conviction.
So I'm going to repeat that and make sure I said that and heard you correctly. At my age, I don't always hear clearly. No reasonable likelihood of conviction. Is that what it says?
Yes.
And to your knowledge, they're not pursuing this in any other way in the future against Chad Daybell. Is that correct?
That is never taken off the table. No.
Okay. But at this point, you don't have an active investigation against Chad Daybell, do you?
There are records that I would like to look at that other agencies have, but like I said, there's no statute of limitations on
Right.
homicide. So
Well,
yeah,
there's
I could
never a
always,
statute. Oop, I'm sorry.
yeah, I could always look at additional records. And if additional evidence came forward, then it could be charged.
But based on the evidence that you presented and the evidence you presented today, that was all provided to the prosecuting attorney, right?
And this is based on evidence as of 2021, yes.
Right. So it's all, they have all the current evidence, right?
I'm not sure if they have other jurisdictions' evidence.
Okay.
They clearly have ours.
Okay. Well, other jurisdictions' evidence, they have evidence that relating to the killing by Alex Cox and Lori Vallow of Charles Vallow, right?
Yes.
And at this point, according to this prosecutor, and that's what, 3 years ago? There's no reasonable likelihood of conviction of Chad Daybell in that matter, correct?
Correct.
Okay. And I could have that back, Mr. Bailiff. Thank you. Now, this is an unusual case because there's a lot of talk about religion.
I agree.
And Mr. Daybell, do you know how long that blessing thing went on for?
I have no idea.
Yeah, me neither. And was it written? Was he reading off of something?
I wasn't there, so I
You
couldn't
didn't,
tell
you
you.
didn't hear pages on the video of him turning pages or anything?
Didn't.
I thought I heard some pages turning.
I heard a garage door open.
Okay, I didn't hear that.
Yes.
Well, all right. Well, you got better ears than I do. We talked about that before. You know what Chad Daybell did for a living, right?
I know he was an author. I don't know other than
Wrote
that, what it
books.
is, yeah.
And as I was listening to that, it sounded like someone was writing a book. Would you agree with that?
Objection, Your Honor. I'm going to ask that the narrative be stricken. I think council can ask questions, but there's narrative being added.
I asked a
Well,
question.
that, I'm gonna make a ruling, Mr. Pryor. So on the last question, I'll overrule that, but to the extent it does become more narrative, Ms. Blake, you can object again.
Now, you know the name's Melanie Gibb.
Yes,
Did you ever interview her?
I did.
Okay. And David Warwick.
I know the name, but I never interviewed him.
And I could represent you that she was dating Melanie Gibb, eventually married Melanie Gibb. So
That
does
sounds
that
about-
recall?
sounds about
refresh
right.
your- Okay. And then Zaluma Pastenes.
Yes,
Okay. All of these folks, members of the LDS faith.
it's my understanding, yes.
Okay. And all of them have made numerous references to some, at least what I would consider unusual beliefs.
True.
Talking about, as members of the LDS faith, they talk about vibrations. We've heard that, right?
Correct.
They talk about probationary periods.
I've heard that term, yes.
Right. And that deals with what you did in your life before in that particular faith, what your role was in life before, right?
If you say so.
Well, I'm asking
really-
you because
I
if
don't.
you don't know about that?
I don't know.
Okay. And then there's some references to God and goddesses. You've heard about that, right?
I have heard that, yes.
Okay. And in the reference to God and goddesses, are you aware that in the LDS faith that as you move forward, you become a god and a goddess in their faith?
I'm not, no.
Okay. And are you aware that in the LDS faith that when you, their God lives on a planet and then angels are brought down to communicate with us?
I'm not familiar with that, no.
Not familiar. How long were you involved in that faith?
Until I was 18.
Okay. So is it because you're not aware of it or is it because you don't believe it was part of the faith?
No, I chose to practice a different religion.
Okay. So you're not aware. You're just telling me you don't know whether it's true or not.
Correct.
Okay. Thank you. And we're not trying to you agree with me, we're not trying to disparage the LDS faith, right?
No.
We're just trying to point out that the stuff they're talking about may not be something that's out of the realm of discussion within that faith, right?
I would agree.
When you're talking about spirits and exercising spirits such as Ned, I guess we talked about Ned, right? That wasn't with you with Ned, never mind. But that's all of this stuff, because these folks were all actively involved in the LDS faith. These are things that came up as
Your Honor, objection. Counsel stating facts, not in evidence. And again, this is a narrative.
Sustained.
now, you investigated this case, and there was a time when J.J. Vallow was exclusively with Charles Vallow and Lori Vallow wasn't involved. Do you have any recollection of when that took place?
I'm not sure the time frame on that, but I know that JJ was with Charles in Texas, yes.
Right. And at that time, Lori Vallow, and it's in this time period, right?
I'm not sure. I wouldn't be able to speak to the exact time period.
Okay.
There's so
Do
much
you know,
different.
do you know where Lori Vallow was living at that time during that 2 or 3 month period?
I don't recall.
Okay. All right. You don't have any recollection of that.
Correct.
Okay. So you're not suggesting, because Chad Daybell gave Alex Cox a patriarchal prayer, that in some way he was involved in the killing of Charles Vallow, are you?
I didn't say that, no.
Okay. And from what I understand, and please correct me, you have 18 years more experience than I do. I have 0. Um, giving a patriarchal prayer to someone, regardless of whether you can do it or not, is that a crime in Maricopa County?
No,
Okay, you wouldn't think that's a crime anywhere, right?
correct.
Okay. It may not be the best religious practice. There may be other issues, but it's not a crime anywhere, right?
Correct.
And you would agree with me that just because you give someone a patriarchal prayer, a very, very long patriarchal prayer, that isn't to insinuate that you've committed any kind of a crime, right?
Correct.
Okay. You knew Zalim. No, I'll wait. Go ahead.
You're fine. Go ahead.
I wish I had one. You know about Zaluma Pastenes.
Yes, I do.
Okay, and tell me who she is again.
So Zulima is the wife of Alex Cox and also a friend of Lori Vallow.
Okay, now the friend of Lori Vallow, do you have a recollection of when that friendship with Lori Vallow started approximately?
I do not.
Okay, but the friendship with Lori Vallow predated the marriage to Alex Cox.
Yes, it did.
And you would agree with me that the relationship between Lori Vallow and Alex Cox was close.
I would agree. Yes.
Oddly close?
I don't know much about the relationship as far as the intimacy or how close it was. But yeah, I've heard it described as such, but I have no.
When you say that
understanding
it
of
was, when you say that you've heard that it was described as what type of adjective close?
I just heard that other people thought they were oddly close,
Okay,
but I have no understanding of that.
okay, all right. Okay, thank you. I want to go back to the date of Charles Vallow's unfortunate death.
Okay.
And you talked about that Alex Cox was there and there was some sort of an altercation.
Correct. That's what was told to us.
Okay, and you got that through a 911 call or how?
So it came through obviously 911 call and then a subsequent interview with Alex Cox.
Okay. And at that point, who was present at the time? That my understanding is that was Lori Vallow's house.
Yes.
She has two children. She had JJ Vallow
Yes.
and Tylee Ryan.
Correct.
And at that point, both of those kids were living in the house.
Yes.
And at the time of this incident, both of those kids were present.
At the time of the actual shooting,
Well, at the time of the altercation, both of them were
on
present.
the date in question, all four of them were present.
Right.
Yeah. When Charles arrived.
Right. And at that point, something with Tylee and a bat.
Yes.
Okay, tell me about that.
So what was explained to us through Alex Cox was there was an altercation, an argument between Lori and Charles regarding Lori taking Charles's phone from him, demanding the password to look into the phone. During that time, the argument continued. Tylee reportedly came out of her bedroom with a bat, and it was grabbed by Charles and pulled away from Tylee. It was that bat that Alex claimed that he was hit in the head with during this altercation. And then during this time, Lori had left the house with Tylee and JJ.
So Lori left the house with Tylee and JJ and she was outside or something like that, right?
That's my understanding, yes.
Right. And at that point, Alex Cox took out a gun and, in your assessment, murdered Charles Vallow.
Yes.
Okay. And there's no indication that Mr. Daybell had any text messages or communication with Lori Vallow or Alex saying, let's kill Charles Vallow, right?
Not in those words, no.
Well, not in any words.
Correct.
So why'd you say not in those words?
Through this investigation, 2 days prior, I uncovered some messages between Lori and Melanie.
Melanie.
I believe it was Melanie Bedreau.
Okay.
And during that time, Lori had sent Melanie a message saying to give her 5 minutes. She's trying to find out what to do.
Okay.
And
We don't, that's a very generic term. That doesn't really imply anything, does it?
correct.
Okay. Now, one of the things I noted on your exhibits. You talked about, and this was on the Lori for Styles on the second page of your exhibit. It was,
Could you reference which exhibit, please, Mr. Pryor?
Judge, I don't have the number. It was the Lori for Styles. Well, maybe I do have the number.
Might be 49.
I think so, Judge. Could we hand that?
Well, so the exhibit's actually the PowerPoint. I don't mind the witness being handed a print off version as long as we clearly state which exhibit that's coming from.
Judge, I could actually see if he can remember it because it's really actually a very short question. If I
Go ahead.
may, I Judge?
Yes,
So there was some discussion where you read off the exhibit, and this was in the Lori for Styles, where you said, it's not Ned, it's a new one.
Yes,
Okay, and that was from Lori Vallow to Alex Cox.
correct.
So when I hear it's not Ned, and your suggestion is that Ned was someone who was possessed Charles Vallow's body, is that right?
Yes,
And what I read from that is it's a new one that's possessing Charles Vallow's body now. Would that be a fair assessment?
yes, that would be a fair assessment.
And is it a fair assessment to suggest that when you're trying to extricate a spirit in the LDS faith from someone's body, you pray and that's how you get rid of a spirit?
Once again, you're talking out of my expertise.
Okay, that's okay. And I appreciate your honesty. Then there was some discussion from Nicole Earl to Lori Vallow. And Lori Vallow talked about, at least for yes, she awoke in the night coughing, threw up, collapsed, and passed away. And she said, oh my gosh, I did not hear that it's Hawaii, it's 6 a.m. So Lori Vallow on that day of 10/19/2019 at least expressed shock at the death of Tammy, right?
Yes,
Okay. And then subsequent to that, she's talking to some Melanie, and that's Melanie Gibb.
correct.
And they had a discussion, and Lori again is acting like she's surprised.
That would have been later in the day, yes.
Right. And then there were other numerous references where you talked about the fact that Lori Vallow may not have been completely honest about things.
In what way?
Well, is it your impression that she was manipulating some of these people?
I don't know if I'd use the word manipulation.
Okay. Okay. All right. Now I want to get to the phone call to the funeral home.
Yes,
Okay. Now at that point, when was that again? I'm sorry.
I'm not sure the date on that. No.
Okay.
Oh, actually, I am. Sorry. That is the evening of Charles Vallow's death.
Okay. And at that point, Lori Vallow and Chad Daybell were having an affair,
Yes,
and they were involved in a relationship.
correct.
And Chad Daybell, that's not something you want someone to find out about. Would you agree?
I would agree.
Yeah. I mean, if you're involved and have a wife and then you're making phone calls. But when he first called, he used his real name, right?
Yes,
He said Chad Daybell.
yes,
And then as it's going on, he maybe told some untruths, right?
correct.
So if he tells people his real name when he's trying to cover up an affair, it's not the smartest thing to do to suddenly say other things when you've already told him who you are, right?
I'd agree.
Okay, all right. And that doesn't mean that he was involved in any way in the death of Charles Vallow, does it?
That phone call alone would not indicate
No,
that.
that's what they talked about, no likelihood of prosecution because he made a phone call to a funeral home about that, right?
I don't think that no likelihood in prosecution was directly related to the phone call.
Okay, it was directed actually to all of the evidence in whole up until the 21st of this year is what
Yeah.
it was it involved, didn't it?
Correct.
Now, I want to go back and then we're done. I promise we're done. Okay. I want to go back to the parochial prayer. Did you have an occasion to look into Alex Cox's background a little bit?
I did not know.
Okay. Were you aware that this parochial prayer was approximately 2 weeks before Alex Cox passed away?
That sounds about right, given the
Okay.
date. Yeah.
And Alex Cox, his death was ruled and determined after an investigation to be natural causes.
Correct.
So there was no funny business with Alex Cox, right?
That we know of, yes.
Well, they did an independent investigation,
Yeah.
right? Okay. Were you aware that prior to the parochial prayer that Alex had been seeking medical treatment for a number of medical maladies?
I was not.
Were you aware that Alex traveled to Mexico to get cheap?
You're on. Actually, I'll withdraw.
Go ahead. You can continue, Mr. Pryor.
Are you aware that Alex Cox traveled to Mexico before that to seek cheap medical prescription drugs to treat medical maladies that he was suffering from?
I am aware of that, yes.
Okay. And you were aware that because of Alex Cox's illness, that Chad Daybell, at the request of Lori Vallow, gave Alex Cox a parochial prayer?
I don't know if that's the reason why I gave it.
Okay. All right. Judge, I have nothing else. Thank you, Your Honor.
All right, that'll conclude cross. This time we can have the states redirect.
Detective Duncan, were you personally involved in anything to do as far as an investigation or responding to Alex Cox's death?
I was not.
And you indicated you were aware that he'd gone to Mexico.
I was aware that he went to Mexico. That's all that I knew.
So you don't know what he purchased
I
down
don't
there?
know.
what
I know he purchased some medication, but I don't know what.
So you don't know what medication he purchased or what he took?
No, I do not.
Did he die shortly after the trip to Mexico?
I'm not sure I don't know the exact date he went down and then relative to his death.
But you also don't know what he purchased.
Correct.
And he'd received that blessing, and counsel had indicated just a couple weeks before his death. Is that correct?
So November 24th was that blessing date.
And so if you were told he died December 12th, does that sound right?
That does, yes.
So on November 24th, Chad talks to him about crossing over, about his time here being done.
Yes,
And then December 12th, he's deceased.
correct.
When you're doing a homicide investigation, is a focal point the day of the actual killing?
Yes,
So in this case, is it fair to say that you really focused in on July 11th?
correct.
And then ultimately, did you look at times before and after July 11th as part of your investigation?
Yes, I did.
And to be clear, I guess for the jury's benefit as well, July 11th of 2019.
That is correct.
So you were asked about these messages that were deleted from between Chad and Lori.
Yes,
Is that why you included those and focused in on them?
absolutely.
And the content was missing,
Correct.
but they were in fact sent in close proximity to the time Charles was killed.
Yes,
And I think counsel had asked you, or you had started to answer a question from counsel about some messages between Lori and Melanie around the time of that July 11th date. Counsel cut you off.
yes.
Could you finish what you were saying there?
Yes, as I indicated that on the 9th of July, there was some conversation or text message that Lori sent to Melanie to give her 5 minutes that she was trying to figure out what to do. At that time, she was talking to Chad Daybell on the phone.
You were also asked about a couple of assessments that you made. And one of them counsel asked, was it your assessment that Alex murdered Charles?
Yes,
In your assessment, did he act alone?
I don't think he did, no.
You were asked a lot about what the prosecutor recommended in relation to Chad Daybell and Charles killing.
Yes,
Was something submitted to them to review in relation to Chad Daybell?
yes,
And you were also asked if the text messages alone made you think Chad Daybell was involved.
correct,
And you were asked if the blessing alone made you think he was involved.
correct.
And you were asked, I think, about some other things to say, and I think your response was not alone,
Correct.
that alone didn't. Counsel asked about your assessment. In your assessment, did you recommend charges for Chad Daybell?
I did.
I have no further questions.
All right, thank you, Ms. Blake. Any
Judge.
recross?
Recross?
If you may, yes.
Your Honor, I would object to recross. I don't think I went outside the scope.
Oh, he went in.
If we're outside on recross, raise an objection, otherwise I'll permit it. But I will keep that in mind, Mr. Pryor, no new
Right.
areas.
Now, you would agree with me that you don't have all the facts as it relates to Chad Daybell, Lori Vallow, and Alex Cox. Is that fair?
Your Honor, I'm going to object. This goes outside the scope of any redirect.
Well, it's a very general question, so I'll overrule the objection.
Go ahead, officer.
The data in this case from every person as indicated is it's voluminous. So I'm sure that somewhere in there, something might have been missed. And so I can't say that I have gone through everything in regards to Chad Daybell that I would like to.
Okay. But you've made a determination that you think that Mr. Daybell is guilty, right?
I said, based on the information that I obtained and the totality of the circumstances, I recommended charges be filed.
Yeah, that doesn't mean he's guilty of anything, right?
Correct.
Okay. And the prosecuting attorneys whose job is to apply the facts that you give him to what the law says made a determination otherwise, correct?
Objection, Your Honor. This was asked and answered, and it's definitely outside the scope of redirect.
Sustained.
Nothing else. Thank you.
All right. Okay, that will conclude the testimony then of Detective Duncan. Before he steps down, I did want to reiterate a limiting instruction the court's providing at times during this trial and will be provided as part of the jury instructions with the jury. So let me provide that instruction and then the witness will be concluded. Ladies and gentlemen of the jury, during the course of this trial, evidence will be introduced for the purpose of showing that the defendant or an alleged co-conspirator has committed acts other than that for which the defendant is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character or that the defendant has a disposition to commit crimes. Rather, such evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So that's the court's instruction. Again, it will be provided as part of your instruction packet as well when you deliberate. That concludes then Detective Duncan's testimony. You may go ahead and step down from the witness stand. Thank you.
Judge, is he excused?
Would he be recalled?
The state does not intend to recall Detective Duncan.
And the defense does not intend to call Detective Duncan. Thank you.
Okay, well, on the issue of that exclusionary order, then if Detective Duncan follows the case any further, he may be prohibited from testifying if he is recalled for any reason. So, thank you. All right, counsel, I wanted to continue on to 3:30 if we could today. Does the state have another witness they'd like to start with, or do you want to discuss scheduling?
Your Honor, the state would call Mark sorry.
All right, well, let's go ahead and get another witness going. And again, we'll conclude today at 3:30.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Also, just speak into the mic and you have the water there.
All right, before we get started, what is your preferred title? Is it officer or agent or some other title?
Special agent is fine.
Special agent. All right, special agent, before you testify, let me just ask, now that you're under oath, have you reviewed any of the previous testimony offered in this case?
No, I have not.
So you haven't observed any on the court's live stream?
No.
All right, Mr. Wood, you can inquire on direct.
Thank you. Can you state your name and spell your last name for the record?
Mark Saari, it's Saari.
What is your occupation?
I'm a special agent with Social Security Administration Office of the Inspector General.
Right. And how long have you been doing that?
Approximately 5 years.
Tell us about that. What do you do as a special agent?
So I investigate allegations of fraud, waste, and abuse within Social Security Administration.
And how does one become qualified to do that?
So I was a prior Deputy U.S. Marshal for approximately 13 years. I have completed the Criminal Investigator training program at the Federal Law Enforcement Training Center in Glencoe, Georgia. Glencoe, Georgia.
How did you become involved in the investigation regarding Tylee Ryan and JJ Vallow?
So in or about January of 2020, the FBI out of Phoenix, Arizona contacted our office and to locate the whereabouts of JJ as well as Tylee Ryan.
So you were referred to it by the FBI?
Correct.
And I'm sorry, when did you say that was?
In or about January of 2020.
What was the purpose of your investigation?
To determine if the whereabouts of the children were to be located as well as if there's any kind of Social Security fraud involved.
What did you do in furtherance of your investigation?
So I met with local law enforcement, met with the FBI, as well as had several subpoenas issued as well.
I want to talk to you about Tylee Ryan. Did Tylee Ryan receive Social Security benefits?
She did.
Why did she receive Social Security benefits?
She received survivor benefits based upon her father, Joe Ryan, who died on April 3rd, 2018.
And how much did she receive a month?
Approximately $18.59 per month.
Where she was a minor child, was there a guardian or someone who represented her in those payments?
Yes.
Is there a name for that individual?
Lori Vallow.
And is there a specific, is it fair to call her a representative payee?
Correct.
As part of your investigation, did you look into what bank accounts Tylee Ryan received these Social Security benefits?
Yes, I did.
Do you know what bank account she received those benefits in?
It was to a JP Morgan Chase account.
And do you know if, where she was a minor, was her mother also on that account?
I believe she was, yes.
Did the bank account she received payments into ever change?
Yes.
What did it change to?
To a BBVA account.
And do you know when that happened?
On or about August 20th of 2019.
Would there have been a notice regarding that change mailed to the representative payee or Tylee?
Yes.
And through your would that have been an automatically generated notice?
Yes, correct.
And in your investigation, have you uncovered such a document?
I have.
Your Honor, I'd ask that the witness be handed States Exhibit 114A.
Yes.
And you can save a trip. He's already provided me a copy and I'm no objection, Judge.
All right, I'll quickly look.
Your Honor, I just realized I did not provide courtesy copies to the court earlier as well.
Okay, and I'll just take a look at it as well. All right, Exhibit 114A has been offered without objection. It is admitted.
Detective, what is Exhibit 114A?
This is a notice sent by the Social Security Administration to Lori Val on behalf of Ty Ryan on August 27th, 2019, notifying of the bank change that happened.
And does it state the change, or I'm sorry, did you say what date it was sent?
The letter was sent on August 27th, 2019.
All right. And this just establishes that that bank account changed.
Correct.
Did Tylee Ryan stop receiving Social Security benefits?
She did.
When was the stop date?
In or about January of 2020.
And do you know why, through your investigation, those payments stopped?
Due to her whereabouts being unknown, our agency turned off the benefits.
And are you aware of a last known sighting of Tylee Ryan?
Judge, I'm gonna object. It's calling for him to make a determination based on hearsay.
The way that question's worded, I'll sustain that.
I'll retract the question.
Thank you.
I want to talk to you really quickly about JJ Vallow. Pursuant to your investigation, did JJ Vallow receive Social Security benefits?
Yes. Why
did JJ Vallow start receiving Social Security benefits?
Due to his father, Charles Vallow, dying on July 11th of 2019,
And do you know how much he received?
$19.51 per month.
And do you know when those payments began?
It's in September 18th, I believe, of 2019.
Did he also have a representative payee?
He did.
Who was his representative payee?
Lori Vallow.
Okay, so the same as Tylee's.
Correct.
Do you know when JJ Vallow, or did JJ Vallow's payments stop?
They did.
Why did they stop?
Due to his whereabouts being unknown.
And now I want to ask you a couple questions about Lori Vallow. Did Lori Vallow receive Social Security benefits pursuant to your investigation?
Yes, she did.
What kind of benefits did she receive?
It was called Mother, Child, and Care. So essentially, she was married to JJ's father at the time of his death. So she received a benefit for taking care of JJ during that time period.
So she received payments tied to Charles Vallow's death as well.
Correct.
Essentially for being the mother to a minor child who was receiving payments.
Yes, correct.
And do you know when those payments started?
It would have been the same day as JJ, so on or about September 18th, 2019.
And do you know what her monthly payment was?
Approximately $19.51 per month.
Did the monthly amount she received ever change?
It did.
Do you know why?
In January 2020, I believe there was a small U.S. Treasury reclamation, or money was taken away from the account based on her a debt she owed, I believe, to the U.S. Treasury.
And did her payments ever end?
They did.
Why did they end?
Due to JJ's whereabouts being unknown.
When a person receives Social Security benefits, pursuant to your knowledge as a special agent and through your investigations, if they have certain changes in circumstances, are they required to notify the Social Security Administration.
Yes, they are.
What are some of those circumstances?
If the recipient or child moves from the address, if the person dies, if the custody of the child or person changes, that kind of thing.
In fact, and are individuals who receive Social Security benefits, are they notified that they are required to give that notice to the Social Security Administration?
They are.
Your Honor, I'd ask that the witness be handed States Exhibit 114B.
There won't be an objection to that either, Judge.
Okay, I'll just briefly review that before it's admitted. Exhibit 114B is admitted.
Thank you, and may I publish that to the jury?
You may.
And Your Honor, may the witness have another copy of that while
No
I publish?
objection, Judge.
If we have one.
I do.
I have it.
Okay. So, and to be, I don't know if it matters, Mr. Wood, but what should be published is the exhibit, not the copy.
Right. What
Okay.
I have is the exhibit that will be published.
Okay, and then I will allow the copy to be provided for reference to the witness.
Special Agent, what is this document?
This is the copy of the reporting responsibilities that were given to Lori Vallow upon the application for JJ Vallow.
And would that have been an automatically generated document?
Yes, correct.
And it would have been mailed to her?
Either mailed or handed to her directly. Either two of those would have happened, correct?
All right. And you said this lays out the notification requirements.
It does.
And what page is that on?
Page 1, I believe.
It starts there.
Page 5 of this document, but yes.
And so what are, again, you stated before, but what are some of the requirements that require notification for a change in circumstance?
On here and notes any beneficiary dies or becomes unable to handle benefits. That would be one item on this document.
And if a beneficiary moves, are they required to notify the Social Security Administration of that change?
They are.
And you stated earlier, if one of the child beneficiary dies, they're required to report that?
Yes, correct.
If a person such as Lori Vallow, who's receiving parent and care payments, if they remarry, are they required to provide that information?
They are.
Special Agent, pursuant to your investigation, did Lori Vallow ever report to the Social Security Administration that Tylee Ryan died or was missing?
No.
Did Lori Vallow ever report to the Social Security Administration that JJ Vallow died or was missing?
No.
Did Lori Vallow ever report that Tylee and JJ had moved from Arizona to Rexburg?
No.
Did Lori Vallow ever report to the Social Security Administration that she married Chad Daybell on November 5th, 2019?
She did not.
And did Lori Vallow ever report to the Social Security Administration that she moved to Hawaii in November or December of 2019?
She did not.
Special Agent, the funds from Social Security, before they're paid out, who do they belong to?
They belong to the U.S. Treasury, which is part of the U.S. government.
Just one moment, Your Honor. Your Honor, the state has no further questions for this witness.
Very well. I'll allow cross at this time then, Mr. Pryor.
Thank you, Judge.
This is the exit.
Good afternoon, Special Agent.
Good afternoon.
Now, I heard a lot about Lori Vallow. Lori Vallow didn't do this. Lori Vallow didn't do that. Lori Vallow didn't notify of the deaths or moving. Are any of these documents or is this case involved in any capacity with Chad Daybell?
No,
Chad Daybell's not on any of the documents.
correct.
Chad Daybell is not under any obligation to report that he married anybody in particular, correct?
Correct.
And Lori Vallow is the one, if she's failing to do any of these acts, Mr. Daybell is not obligated to say anything, correct?
Sorry, repeat the question again?
Well, Lori married Chad Daybell. At that point, is Mr. Daybell obligated under the Treasury laws to report that to the Treasury Department for Lori Vallow's SSA payments?
I think if he were aware that there was a violation of what's happening with the reporting responsibilities, it would probably be a problem for him. I would agree with that, actually.
Okay.
To repeat that, if he was aware that she had responsibility to report that, and that's actually a federal violation, and he was aware that did not support that, I believe that would be a problem actually for our agency to investigate.
It could be a problem.
It could be, correct.
Okay. But primarily, the person who's failing to report making those representations is the one who's primarily criminally responsible. Would you agree with that?
That's probably accurate, I would say, yes.
Yeah. And it would be unusual for a spouse to report on their own spouse that, oh, by the way, they're not, they didn't report about the benefits. It's really the onus is on the person receiving the financial assistance, right?
I would say so.
And that financial assistance was being put into Lori Vallow's independent account, correct?
Correct.
Okay. Okay. Now, if I'm adding this up correctly, you said Lori Vallow was getting $18.59 a month commencing when?
In or about September 18, 2019.
And was that because of a death? What was the
For
reason for that check?
JJ or for
Tylee?
For Tylee? That was for her father dying in 2018.
Tylee's father dying.
Correct.
Okay, so Tylee's father died and Lori Vallow. Do you know when did that come in? That check started?
For Tylee?
Yeah.
Her father died in April of 2018, so she would have applied for benefits after that date.
Okay, so he died in April of 2018. Okay, and at that point, she was getting or after she applied, she was starting in September of 2018, she was getting $18.59 a month, right?
September of 2019, she was receiving $18.59 per month. Every year increases based off of COLA, so it would have been a little bit less, I believe, in the previous year to that.
Okay. And at the same time, she was also getting this mother-child care as well, right?
In regards to Tylee?
For Tylee, did she get the mother-child care?
Not true, no. It would be for JJ.
Okay, well, I was just asking whether she did, so it.
Okay.
Okay. And then JJ started getting the Social Security payments. Is that right?
In September of 2019, correct.
Okay. As far as Tylee is concerned, the Social Security payments end when?
In January of 2020.
In January of 2020, the payments would end, right? Is that what you said?
Based upon our stopping the benefits for her, correct? Yes.
Okay, what about age? When do the benefits end as far as age?
If she turned 18, they would have stopped.
So if Tylee had turned 18 years of age, they would have stopped automatically anyway, correct?
Correct.
And at the time of Tylee's death, do you know how old she was?
I don't have the exact age for her at that time. I don't.
Okay, that's okay.
Yeah.
That's okay. And then as a result of Charles Vallow's death, JJ started receiving 1951 a month.
Correct.
So my math is not great. We're about $3,800 between the two kids just from Social Security benefits. Is that right? That Lori Vallow received
Are you asking per month or what time period?
per
are you
month,
asking?
per month.
I'd have to like add it up, but it'd be 1951 times 2 plus 1859 per month. So I don't have a calculator in front
Oh,
of me.
I'm sorry. That's right. The child throws another $1,900 in there as well, right?
With mother, child, and care, correct?
So 39 and 18, we're north of $4,800. $5,800 a month approximately, right?
I'd have to add it up, but it sounds right to me.
Okay. And that's money that she receives every month. And only because her third husband died, right?
Correct?
Her fourth husband died, correct?
Correct.
Okay. And then at some point, those funds would continue until the children would reach 18 years of age. Is that fair?
They would with one caveat. If
Okay.
we had sent a letter to her address in that time period and the letters were being returned to us, we would have stopped benefits immediately based off of that happening.
Okay.
So at some point, we would have probably be sending letters to the address in Arizona. We would have stopped benefits based on the letters probably being returned to us. So
But I'm talking in generalities. In generalities, if nothing had changed and everything remained the very same, and it just continued on with until both children reached the age of 18. Potentially, she would be, until Tylee turned 18, you'd be looking at almost $5,800 a month in payments for just the kids to her. Would that be fair?
until the children aged out, I believe that'd be correct.
Okay, all right. Judge, I have nothing else. Thank you, Judge.
All right, thank you, Mr. Pryor. State have any redirect?
Your Honor, the state does not have any redirect,
All right, is this witness intended to be recalled?
not by the state.
Not by the defense, Judge. Thank you.
Okay, that'll conclude your testimony. Thank you for appearing. Can I have a quick counsel sidebar, please? All right, thank you, counsel. Given the timing, court suggested maybe we break for the day before starting with the new witness and just breaking that up immediately. So is the state okay to conclude for the day? And if so, who will be taking the stand tomorrow morning?
We are good to conclude, and Chuck and Sidus will be starting in the morning.
All right, is the defense okay if we stop now?
Yes, Judge, thank you.
All right, ladies and gentlemen of the jury, then, thank you for your attentiveness today. As we break for the day, I will admonish you, please do not do anything to investigate the case, look into the case in any way. If you see it reported somewhere in the media inadvertently, please try to divert your attention from that and don't talk about the case amongst yourselves or with anyone else. You'll only be able to do that once your deliberations commence with each other. So with that in mind, we will go ahead and conclude for the evening, and thank you all in attendance in the courtroom today for abiding by the court's order in relation to courtroom conduct. With that in mind, then we're in recess until tomorrow. We'll start again at 8:30.
All right.
270 meters in closing. Crew Dragon expected to converge with waypoint 1 directly in front of the International Space Station in less than 5 minutes. You can see the views right over the shoulders of Commander Shane Kimbrough and pilot Megan MacArthur. Kimbrough on the left, MacArthur on the right from that view.
From this view from the International Space Station, you can see what we were mentioning earlier, where Dragon was below the station. You could see that previously when it had Earth in the background. Now it is almost adjacent, or almost in the same orbit as the International Space Station, as it's making its way to the docking axis at waypoint 1. This maneuver from below the station to in front of the docking port is almost complete, just a few minutes away.
Getting great views from all around, from the station side, from the Dragon side. The outline of the station you see on the displays inside Crew Dragon is in line with the position of where Dragon is relative to the International Space Station. It's almost at the docking axis, about 2.5 minutes to go until it converges with waypoint 1.
And as a reminder, Dragon is flying autonomously, so they aren't using those display panels to fly Dragon. They're just using them to monitor each step of the way. So the crew is basically just patiently waiting until they dock with the station.
Now seeing Dragon in a better view, a lot more clear now that it's only 240 meters away. You can see the nose cone clearly deployed, extended towards the space-facing side or zenith side.
A really good zoomed in view, and you could almost make out those 4 bulkhead thrusters on the forward portion of the Dragon capsule.
There you go. The Cronus is adjusting the aperture of the station cameras.
Dragon SpaceX on the big loop. Approach 1 and soft capture ring extension will begin shortly. Dragon will continue to waypoint 2. with the additional lighting assessment occurring at 110 meters as previously noted. For awareness, if sunlight results in the loss of the Dragonite geofilters, Dragon will autonomously retreat back to waypoint 1, remaining on closed loop control using the time of flight filters. How copy?
We are in a handover period, so we may have missed a call as we were switching from TDRS satellites. We're looking at about 20 seconds to go until we converge with waypoint 1. There's going to be an approach burn maneuver using the Draco thrusters. That's called approach 1, and that'll move Dragon from right in front of the docking axis 220 meters away and start moving in, closing in to waypoint 2, just 20 meters away from the docking axis. Of course, they'll be monitoring along the way.
We did hear the Corps mention that they are going to have a checkpoint to make sure that there isn't too much sunlight on the space station, which will prevent Dragon from docking. If that does happen, Dragon will autonomously back out and wait until the sunlight has cleared to ensure a good docking with the space station. Because this is all autonomous, it uses some visual cameras to align with the docking port. So it's really important that we don't have that sunlight getting in the way.
Sections over on the big loop, sound check.
SpaceX has you loud and clear on the big loop. Helm me.
Very loud and clear. Your last call, we copied most of it, but you cut out towards the end there. I'm not sure if there's anything important for us.
Copy. I'm going to repeat the end of the call. We did have a TDRS handover. Just for awareness, following the lighting assessment, if we continue but sunlight results in a loss of the Dragonite geofilters, Dragonite will autonomously retreat back to waypoint 1, still on closed loop control using the time of flight filters. How copy?
Okay, we copied all. Thank you very much for repeating.
No problem, Shane. And for awareness, the C2V2 link reconfiguration has been completed.
Copy, C2V2 complete.
And there, the Corps just reiterated that they will be checking to make sure that the sunlight is not in the way of the visual systems between Dragon and the space station. If that does happen, Dragon will autonomously retract and wait until we do get some good visual views for these systems to dock with each other. So
that's right. Crew Dragon resilience actually coming into view a little bit clearer now from the cameras aboard Dragon. Dock to the Zenith port.
Yeah, that was on the upper portion of the screen.
That's right. Now again, to reiterate, Dragon has passed waypoint 1, 220 meters in front of the station, executed a burn maneuver to go ahead and move in. So we're in approach 1, and it's heading towards waypoint 2. Now inside the keep out sphere. It's currently in the process of extending its soft capture ring that'll be used to dock to the international docking adapter of the forward port. We're monitoring the visual systems of Dragon. It would execute an automatic retreat if the sun was interfering with the optical systems as it makes its way towards an approach. We're at about 150 meters away from the station.
And we have such a great camera view here. You can really see the detail on Dragon. Again, those 4 bulkhead thrusters. You could almost read the logo, the Dragon logo on the side of the vehicle.
That's right. We'll get even better views as it makes its way even closer to make contact and capture with the space station.
There it is.
Yeah, based on the trajectory here, we may even anticipate a capture a little bit earlier than anticipating. We were looking at about 2:10 a.m. Pacific time. It might be at maybe closer to 2:07 p.m. The features of the space station coming into view very clearly.
Yeah, you can see a lot of the detail there. And as you mentioned, the Crew 1 Dragon.
SpaceX station on the big loop. Procedure review complete, ready for docking.
Houston copies.
All right, that was confirmation from Victor Glover aboard the International Space Station. From the space station side, he is go for docking. The soft capture ring itself is fully extended. We're 115 meters in closing.
Looking at your screen, the port that we are going to be docking with is directly in the middle of the screen, that circular area on the International Space Station.
Station Houston on 2 for Ike regarding SSC 17 and D2DM. We are seeing some strange configurations on the video, and we would like to close and restart that. We can take care of that from the ground if you would like. Absolutely. If you're seeing nominal, that works for us.
Okay, so Victor Glover aboard the station still has...
And Dragon SpaceX soft capture ring extension is complete. Additionally, we did beat the sunlight for the Dragon Eye filters, so we are not going to command a hold.
Ever copy off.
All right, so that's great news. We passed the 110-meter checkpoint that the ground operators were referencing, making sure the sun wasn't interfering with the optical sensors, the Dragon Eye, that are part of the guidance and navigation and control system aboard Dragon. We passed that check mark. We're good to go. We beat the sun there. So we're now inside 80 meters and closing. Dragon will pause at 20 meters. That's designated as waypoint 2 to conduct a go, no-go poll for the readiness on both the Dragon side and the International Space Station side, making sure everyone is good for docking. If we are go, we expect to dock during this pass over an orbital daytime. Expected in less than 20 minutes. Some of the features there, you can see a lot of the visiting vehicles on board station. At the bottom is a Russian Soyuz vehicle that delivered crew to the International Space Station. Just in front of that, or actually above that, is the Crew Dragon Resilience docked to the Zenith port. Once Crew Dragon Endeavour arrives, there will be 2 Crew Dragons attached to the space station.
And this view from Crew Dragon looking at the International Space Station, it looks like it's this very slow and steady movement, but in reality, they're moving at 17,500 miles per hour.
The rendezvous operations are absolutely incredible. You can sort of see the Northrop Grumman Cygnus cargo craft as well, some of the ultraflex solar arrays coming into view a little bit clearly.
And you could see that Crew 1 Dragon vehicle on the top of your screen. Once Crew 2 docks to the International Space Station, we will have 2 Crew Dragons docked at the same time for the first time.
That view right there was truly a representation truly of an international cooperation there. The U.S.-built Node 2 is where the Dragon will be docking today. It was flanked by the European Columbus module and the Japanese Gem.
On the big loop, visors down.
SpaceX copies. Visors are down. We may enter into a hold at waypoint 2. We are still awaiting ground go for final approach.
Endeavour copies.
The detail of this camera view is pretty incredible. Here from the International Space Station, watching Crew Dragon as it is slowly approaching.
And as expected, Dragon holding at waypoint 2. It's at about 20 meters right in front of the docking axis.
And if you're just now joining us, we are just waiting for a confirmation for go for docking. Currently holding Dragon at waypoint 2. And again, it looks like Dragon is just paused and not even moving, but again, as we just mentioned, both the space station and Crew Dragon are actually moving at approximately 17,500 miles per hour. So it's pretty incredible how it can hold these speeds so that it looks like they are just completely paused.
That's right. Teams on the ground, both from the station side in Mission Control Houston and Mission Control Hawthorne, just checking and verifying all systems are go to proceed with docking.
And when we do begin docking, there will be 2 portions of this. There will be a soft capture followed by a hard capture. The soft capture will be a soft capture ring that basically just connects the Crew Dragon to the space station to enable the hard capture, which will be 12 hooks that will attach Dragon to the station.
Again, we're standing by the International Space Station, flying over the Indian Ocean now, just south of the Indian border. It's heading on a southeasterly course just south of Australia, and should cross over the Terminator line into the Pacific Ocean into an orbital nighttime. The expectation is for Dragon to depart here from waypoint 2 and proceed on with docking ahead of orbital nighttime to beat the sun.
You can see this camera moving around. Again, this is controlled from the ground from Mission Control Houston. And they're maneuvering this camera around so we can just get a more detailed view of the Crew 2 Dragon Endeavour patiently waiting, docking to the International Space Station.
Dragon on its second flight, about to dock to the forward end of the International Space Station for the second time.
And Station and Endeavour on the big loop. Ike, we are not able to recover that video for the D2DM, so you can close that window, and we should be ready to press into final approach shortly.
Station copies.
You did hear that call out speak out to Ike. Ike is actually referring to Victor Glover. That is just his nickname.
Dragon SpaceX on the big loop. Ground is now go for final approach. Upon confirmation of crew readiness for final approach, we will enable the approach. Please confirm crew readiness, and a reminder, once Dragon is inside the crew hands-off point, retreat and breakout are no longer permitted.
Crew is ready for final approach.